Yes.
May I please leadership?
Yes.
I'd like to mention item number 18 and 19. Leadership, I'm yet to receive instructions, so can you grant me 3 weeks time to obtain instruction?
Yes, petitioner.
I have to inform one of the local council who is in for 2.
My lord, I am appearing on behalf of the petition 18 and 19.
Okay, 3 weeks
My lord.
time. You're asking for 3 weeks time.
My lord, previously also they had taken time that they had yet to take instructions from the Department of Lottery and Finance, my lord. And on that account, my lord was pleased to grant them time till for 3 weeks. And now they're again coming up with the same plea that they want another 3 weeks time for taking instructions. My lord kindly goes through the last order. My lord had granted them time. And on that day, although it is not recorded in the order sheet, my lord had stated that to ensure instructions be given from the end of the lottery and the finance department, or else they would be directed to appear in person, the authorized representative from the finance and the lottery department.
That
Leadership,
order
but this is see, notice was issued only on 8th August, and there's no emergency involved here. Now a question of dispute of fact is involved, and unless that criminal petition number 23/2025 is disposed of, this, in fact, this is premature also.
That is their version, my lord. They feel that it is not urgent. My lord, I had won lottery tickets way back in the year 2023. I'm not being given the prize money.
Is it connected with that criminal petition?
Right, my lord. The criminal petition is supposed to be taken up today by the courtroom number 2.
Then we can give them some time if it is connected to the criminal petition. In this petition, what are they praying for?
My lord, we have paid for disbursement of the prize money of the lottery tickets.
And
there are 2 lottery tickets that was won by my client, by the petitioner. One being item number 18 and another being item number 19, my lord. And in both the cases, they have not yet disbursed the lottery prize money. And this is way back dated in the month of March 2023.
And
It's
you are
been more
the
than
accused.
2.5 years, my
You
lord.
are the accused in that criminal petition.
They have made me an accused without getting any documents from any corner, my lord. They have just
that the court will have to see. That is only your submission. In that case, I think we need to give time. Yes,
my lord, I have a prayer, my lord. My lord, it is only about them taking instructions. Why aren't they taking instruction? And they have come up on the very first day and they have prayed that we will file an objection to it. My lord had given them opportunity to file an objection. Now they at least let them file an objection. Why is they not filing the objection? That is my contention. My lord, if my lord grants them time.
Asking for time to file the objection. Yes.
My learned friends even misleading the court. The last order says the learned government advocate submits that he is yet to receive instruction from the finance department and lottery department.
Yes, this is the order 8,
Yes.
9.
That is what how can I mislead my lord?
No. You were saying that the court had directed for personal appearance.
Right, my lord. Right. That is, I have stated that it was not recorded in the order sheet. But the honorable court had, my lord has stated that orally that if they are not being able to give instructions,
we go by the order. Don't say things like that.
No. My lord, my prayer is
by
only.
the order of the court 8/9/2025. Nowhere does it say that the respondent.
No, I understand. I completely understand, my lord.
Lord Learned Counsel for the petitioner, Shri such and such. Please give your name. Your name.
My lord, Mohammed Shamimuddin.
You got it. So also heard Mr. K. Angami, Learned Senior Government Advocate for the state respondents. The Learned Government Advocate has prayed for 3 weeks' time to receive instructions and to file the objections / counter affidavit on behalf of the state respondents. These prayers objected to by the Learned Counsel for the petitioner. Stop. The Learned Government Advocate submits that there's another criminal petition pending in connection with the same matter, which is yet to be decided by this court, and that the criminal petition also has a connection with the present writ petition as the accused slash petitioner in the criminal petition number.
My lord, it is criminal petition number is 23 of 2025.
25 is the petitioner in the present petition.
Yes.
The petitioner
Right, my lord.
in the present petition. Stop. Considering these facts and circumstances, the government advocate is given, the government respondents are allowed 3 weeks' time to file their counter affidavit, which shall be filed positively before the next date. Okay?
Much obliged, my lord. Much obliged, my lord.
Your Lordship, if I may give a
Yes.
mention item 26 and 27. 26 and 27 is here. May I play that the matter will listen after boards.
Heard Learned Counsel, Mr. L. Iralu for the respondent number.
Private response.
Okay, for the private respondent, stop. Learned Counsel for the petitioner is present. No objection?
No objections. Your Lordship.
Petitioner is present. Stop. Learned Counsel, Mr. L. Iralu prays for how much time?
Forwards.
4 weeks' time. Stop. Accordingly, prayers allowed. List after 4 weeks. 27 also.
Your Lordship, I beg to mention item 29 and 30.
Yes.
Your Lordship, if the matter may be fixed for Monday, 15th of October.
On the prayer of the Learned Counsel for the petitioner, list the matter on 13/10/2025 for hearing. Vote, okay, 29.
Your
Yes,
Lordship, I beg to mention item 23 as well.
23, yes.
Yes, Your Lordship. Kindly grant us 4 weeks time to file an objection to the IAA.
Objection to the IA.
Yes, Your Lordship.
Learned Counsel, I miss such and such who has prayed for 4 weeks' time to file an objection to the IA 146 of 2025. Stop. No objections?
Lordship, that objection may be necessary, yes.
Their objection may be
Yes.
necessary.
We
Yes.
have a
Accordingly,
valid position.
is the matter of the 4 weeks. The Learned Counsel for the petitioner, you are for the petitioner,
Yes, Your Lordship.
yes. Learned Counsel, Mr. Apok Pumana appears for the respondent number,
Applicant, Lordship, the applicant. is-
or for the applicant in IA 146 of 2025. Also, heard Mr. I. Jamir for the
Former respondent,
former
43 and 44.
respondent number 43 and 44. Stop. List of the 4 weeks.
Your Lordship,
Yes.
there's an interim.
The interim order passed earlier shall continue till the next date. Yes.
May I please, my Lordship?
Yes.
Lordship, I beg to mention item 28.
Yes.
Lordship, I have some difficulties today, Lordship. If this matter can be listed some next week, Lordship, on 14, 13 it's okay. On Monday, Lordship.
Monday. Let it be 14.
Lordship.
Heard Learned Counsel for the petitioner. Stop. Also heard Mr. K. Angami for the state respondents.
And Angami.
Oh, N. Angami, sorry. I get mixed up with an N and K. For the state respondents who has prayed for listing the matter on 14/10/2025 for hearing. Stop. Accordingly, list on 14/10/2025.
I'm still obliged. Lordship, there's an interim, Lordship.
The interim order passed earlier shall continue till the next day. Yes.
Yes, this your lordship. Your lordship, I beg to mention item number 12.
12.
Your lordship, I have filed my affidavit in reply to the affidavit in opposition filed by respondent 3, 4, and 5 only this morning. So I read the matter be listed on 16.
You are for the petitioner.
Yes, your lordship.
Learned Counsel, Mr. Research for the petitioner who prays for listing the matter on
16 as fixed item.
16/10. 16/10 as a fixed item. Stop. The Learned Counsel for the respondents have no objection. List on 16. 16/10 is okay?
Oh,
16/10, yes. Yes.
Ma'am, this is Lordship.
Yes.
Lordship, I beg to mention item number 22. Lordship, I'm for respondent number 1 to 4, mentioning on behalf of Gauhati. Lordship, we are here to file our affidavit, so if 4 week times may be allowed.
4 weeks.
Yes, your Lord.
Yes.
Let it be 3 weeks, Lordship. Maybe 24 points sometime,
Hmm.
your Lordship.
Otherwise, it's a 25 matter, 2025.
Lordship.
Any urgency?
Also, we're claiming for compensation.
Compensation.
They are illegally occupied
Let them take 4 weeks instead of asking again and again. Heard learned counsel, and such, who makes a prayer on behalf of Mr. Young Arwati, learned CJC, praying for 4 weeks time to file the affidavit, counter affidavit on behalf of the respondents. So learned counsel for the petitioners present, prayers allowed, list of the 4 weeks. Yes,
Obliged. May I please, my lord.
yes.
Lordship, I may be kindly allowed to move 2 unlisted bail applications prior to Puja vacations. This is a peculiar scenario, a peculiar case.
Tomorrow,
No, my lord,
Yes.
I may be allowed to say a few lines.
Mm.
Prior to the Puja vacations,
Mm.
2 bail applications were allowed while my lord was sitting in court too.
Mm.
Now the trial court is refusing to execute the bail order. The accused are still in prison.
Mm.
Saying that no specific direction was given to the trial court to execute the bail order. And the both the accused are still under custody at District Jail Kohima. I have taken the consent of the learned public prosecutor as well. So only for a slight modification in the bail order.
Modification of the bill.
Yes,
order.
yes.
Okay.
Later to be listed to, if my lord kindly allow.
Okay, you can give the
allows.
information.
My lord, I may also be. Item 10,
Mm.
on behalf of my learned friend, Prabhi Chaudhary, he is unable to come today, my lord.
Mm.
So if the matter can kindly be fixed on 7th of November.
David,
Appearing on behalf of my senior for respondent one.
Learned Counsel, Mr. Santianger, who has made a mention on behalf of Mr. Pravir Chaudhary, who could not be present today, and prays for listing the matter on 7th,
My lord,
7th November.
7th November.
The prayer is not objected to by the Learned Counsel for the respondents, list on 7th November. Yes,
My lord, there is an interim.
the interim order passed earlier shall continue till the next day.
Lordship, I may also be allowed to make a mention for item 25. Here,
Hmm.
the steps upon the private respondent.
Hmm.
We have taken steps twice by registered AD. It is yet to be completed, which is why I pray that substitute notice by newspaper publication may kindly be allowed. Within 2 weeks, my lord.
You have taken twice.
Yes,
Step
my lord.
Learned Counsel for the petitioner, Mrs. Santianger, submits that the steps have been taken for notice on respondent number
7, my lord.
7 twice. However, the service report has not yet returned. Accordingly, he has prayed for taking steps for notice by newspaper publication. So accordingly, the prayer is allowed. The petitioner shall take steps for making substituted notice on the respondent number 7 by newspaper publication in local daily, which is widely circulated in Nagaland, and thereafter file the compliance affidavit regarding the notice. Stop list after 3 weeks,
4 weeks, my lord.
list after 4 weeks.
I am simply obliged.
Government advocate and no is present. Yes.
May I please, Your Lord, my lord.
Mm.
Lord, I'd like to mention item 24.
Hmm.
I prayed for 3 weeks' time as we are yet to receive the instruction.
Learned Government Advocate, Mr. M. Nonkumar, prays for 3 weeks' time to file counter affidavit on behalf of the state respondents. Prayer is allowed. Learned Counsel for the petitioner has no objections. List of the 3 weeks. Yes.
Lordship,
Yes.
I've taken the step for dusty service as well as to registered post with ED for private respondent one.
It's okay. Have you filed your affidavit?
Yes, Lordship.
Okay. Learned Counsel for the petitioner also submits that he has filed the compliance affidavit in respect of dusty service on respondent number
5.
5. Stop. Yes. Yes, after 3 weeks.
My lord, I also like to mention item 14 on behalf of AT Bako. I prayed for 3 weeks, Your Lord.
14.
Yes, 14.
Learned Government Advocate, Mr. M. Nonkumar, prays for 3 weeks' time to receive instructions and to file affidavit on behalf of the state respondents. So prayers allowed. Learned Counsel for the petitioner is present. List after 3 weeks. Yes.
May I please, my lord. Lordship, in item 25.
Hmm.
There is an interim. If can kindly continue to the next agenda, please.
25. Interim order passed earlier shall continue till the next date. Yes.
Much obliged.
May I please, Madam?
Hmm.
Melody, if I may be allowed to mention for item 37 to 41, listen and listen item. The status file affidavit in opposition.
37 to 41.
Yes, I want to file affidavit in reply and it's on the process. If a one week's time will be granted to me.
37
37
to
to 41.
41, okay. Learned counsel for the petitioner, Mr. Tushilong Kumar, submits that the affidavit has been filed by the state respondents and he needs 1 week's time to file a reply to the same. So accordingly, list after 1 week.
It can be listed on 16th.
Let's see after 1 week, so it will come up.
Yeah, please, Your Lordship.
Yes.
Lordship, I beg to mention hearing item number 31 on behalf of senior counsel Zasita. Lordship, the senior counsel is not well, so the matter can come up after 2.
Third learned counsel, Miss Such, your name,
Hello.
who has made a mention on behalf of the leading counsel, Mr. Zasit Sole, to list the matter after 2 weeks as the counsel is indisposed. So prayer is allowed to list after 2 weeks. Learned government counsel, Miss Inauli is present. Yes.
Please, Your Lordship, I may be allowed to mention item 20, Your Lordship. Here I'm with, instruction is still awaited, so I may be kindly related 3 weeks' time. Item 20.
Item 20. Petitioner,
Your Lordship, I've taken consent.
okay. Learned government advocate, Miss Inauli prays for 2 weeks.
3 weeks, Your
3
Lordship.
weeks' time to receive instructions and to file the affidavit on behalf of the state respondents. Prayer is allowed list after 3 weeks. Yes.
Your Lordship, similar prayer for item 21, Your Lordship. Here also instruction is still awaited, so.
21
2
also
weeks may
same,
be granted.
3 weeks. And here, learned counsel for the petitioner, Miss Such and Such present. Yes.
Obliged, Your Lordship.
Yes.
Lordship, I beg to mention item number 43. On behalf of Lim Dim Song, petitioner I have to consent with the petitioner. Kindly here, we are yet to receive instruction. So kindly grant 3 weeks of time to file our affidavit.
Yes,
We have to-
Mr. Elirado. Have you informed them?
Yes, Lord.
Lieutenant Counsel, such, who praises on behalf of Mr. Im Tiem Song, additional AG, to list the matter after 3 weeks.
3 weeks now.
3 weeks in order to file the affidavit in opposition on behalf of the state respondents. So prayer is allowed list after 3 weeks. Yes.
Lordship, again, item number 11. Here, on behalf of S. Shah, today she has some difficulties. And here affidavit is under preparation. So kindly grant 3 weeks of time to file affidavit.
Learned government advocate, so and such, who mentions on behalf of Miss S. Chang.
S. Shah.
S. Chang, who's appearing in the present matter to list after 3 weeks in order to file the affidavit on behalf of the state respondents. So learned counsel for the petitioner, and Ms. Such and Such is present. Also,
Private one.
Mr. Foseko is present for the private respondents. Stop list after 3 weeks is prayed for. Yes.
Lordship, similar prayer, item number 16, Lordship. Let this matter come up Thursday, Lordship. Yeah,
Item
first shot.
16. Okay. Here, pleadings complete.
Lordship, yes.
Pleadings are complete.
Lord,
No, if I may, Lordship,
Yes.
as per the previous order, there, it was mentioned that there shall be no further adjournment. As per,
No, since the council is not there today, the government council, S. Chang,
Lordship, Thursday.
okay, Thursday,
Lordship,
on behalf, prayers made on behalf of Miss S. Chang, government advocate, to list the matter on Thursday. Give the date, okay, 16th, yes. Learned counsel for the petitioner is present, list on 16th. Yes.
Similar prayer, Lordship, item number 17. Here, we receive our instruction, so she's under preparation. So kindly grant 3 weeks of time to file affidavit.
Same order, 3 weeks time. Learned counsel for the petitioner, Miss Such and Such present. Yes.
Lordship, again, item number 32, behalf of Lee Zimmerman.
The whole list is gone. Why you don't want to take up hearing
Yes,
matters?
32.
Let's take up at least 1 or 2 a day. Yes, 32. You know what happens?
Lee Zimmerman, behalf of Lee Zimmerman.
How much time?
2 weeks, Lordship.
2 weeks.
Lordship.
What happened? What's his problem?
Lordship, Now he's in court too.
Okay. Learned Government Advocate who makes a mention on behalf of Mr. V. Jangomi, Learned Government Advocate, to list the matter after 2 weeks.
okay.
After 2 weeks. So Learned Counsel for the petitioner is present and has no objection. List after 2 weeks for him. Yes.
Yeah, Mr. Lordship.
Yes.
My lord, allow me to mention item number 15. Item number 15. My lord, here I have received the affidavit in opposition filed by the private respondent this morning. And I'm told that the state respondent will not be filing the affidavit in opposition. So if this can be fixed on 23rd of October for final hearing in disposal. For admission hearing.
For admission hearing,
My lord is.
government is
And-
not filing.
Yes, my lord, I'm told. And in the meantime, if necessary, I'll be filing affidavit in reply to the affidavit filed by the private respondent.
Learned Counsel, Mr. Taka Kichu is present for the petitioner. It is submitted that he has received the affidavit in opposition of the private respondents and therefore he would like some time to file a reply to the same if so advised. So Learned Government Advocate, Ms. Livika is present, submits that. Livika, you are not filing affidavit. And submits that the government will, or that the state government will not be filing any affidavit. So accordingly, list the matter for admission hearing when?
On 23rd October.
On 23/10. Yes.
Obligation.
From the supplementary cost list for motion, item number 33.
Yes, what is this?
Please, Your Lordship.
Yes.
Lordship, the petitioner is seeking intervention of this court because his livelihood is going to be affected, Lordship. Lordship, the facts of the case in brief is that in the year 2012, Lordship, the Department of Jail Prison, Lordship, under Mohawk Chung, the district headquarters, Lordship. Now, the jail authority has allotted a small plot of land to the petitioner, Lordship, saying that the town they're facing a water crisis, and then there's no other alternative, Lordship.
Temporary allotment.
Yes, so yes, it was allotted, Lordship. Now, if you see page number 36, here's also the superintendent, the then superintendent, Lordship, who is respondent number 4, has in his statement stated, dated 11 November 2012, saying that, Lordship, if it will allow me to read, to whom it may concern, page number 36, Lordship. This is to certify that the resident of District Jail, Yim New Ward, Mokokchung, is facing crisis of water supply. We have been requesting to meet this crisis and solve the problem, but till date, nothing has been done due to scarcity of water at Mokokchung town. As such, we have found that a very reasonable person, Mr. Wabang Tumjin, who is the petitioner, Lordship, who can really help in supplying of water for the whole residents of the Yim New Ward in general and also in jail colony. I therefore request the concerned authority to kindly allot the site to the above mentioned person for construction of water reservoir at the jail acquired land. Now, to effectuate this, Lordship, the petitioner was approached. Now, petitioner, he has in fact nothing to gain. The thing is, it's not a public procurement project also, but he was simply allotted the land to construct the water reservoir, which he made out of pocket expenses, Lordship. Back in 2012, he made more than, Lordship, 20 lakhs approximate expenses for the construction. He also made approach road. The land was located inside. It's very steep, Lordship. It's not usable. You have to level, put all the pipings, pipelines, fittings, electricity connected, everything, Lordship. He has done that. Now, to that effect, they have executed. The jail authority and the petitioner executed an agreement, Lordship. Now it's in page number 37, Lordship. Lordship, allow me to read. This agreement is made on this day, the 8th of November 2012, between Superintendent of District Jail Mokokchung, Nagaland, referred as the first party, in one part, and Mr. Sri M. Wabantangjum of Kensa village, residing at Yumnu ward, referred as the second party in another part, do hereby agrees as under. Due to scarcity of water at district jail Mokokchung, the first party is agreed with the second party to allot a plot of land to the second party to construct temporarily water reservoir tank and related purposes, etc. on the land occupied by the district jail Mokokchung to distribute water to the jail inmates, and therefrom second part shall supply at least 2,000 liters of water per day to the first party. That the first party shall pay rupees 5,000 per month to the second party for supply of water. That both parties had agreed to enhance the rate after every 3 to 5 years. Therefore, it is agreed between the parties that this agreement shall be enforced from the date of this agreement. Now, accordingly, the land was also allotted. To that effect, the same agreement was added again on the 16th day of November 2016 with the same terms of condition. And now this time they have registered it before the Notary Public Lordship. Now, after using the service of the petitioner for more than 12 years, Lordship, without any justification, the impugned decision was taken on 9th April, Lordship, 2025, saying that the petitioner has to hand over the water reservoir to the jail authority, and then the management has to be decided on upon by the district administration, who is a stranger to the contract, Lordship.
Where is the impugned order?
Lordship, it's in
Page 8, page 9.
yes.
Annexure 9.
It's in page number 42, Lordship.
No, this is the meeting minutes.
Yes,
Same
no,
minutes.
based on this decision, Lordship, petitioner was directed to, it's not an order also, in fact, Lordship. He was just given an order. It was just on this day he was summoned. He willingly went to see what is happening. And then allegation was also put against him, saying that he have misused land allotment, which is not true.
No, it is government land.
It is government land. That is not disputed, Lordship. That was not disputed, Lordship. But now the question is that since there's a water scarcity, Lordship, this reservoir is catering to the needs of the public. Now there are many unemployed youths, unemployed persons who are drawing water from this reservoir and then supplying it to the other citizens in the district, Lordship, in the town, Lordship. Now, if this court is not intervened, Lordship,
At best, yes, who's appearing? Yes. Notice should be given to you.
Lordship, I have
And then,
temporary,
and
Lordship.
then compensation also, if you're taking it back,
Yes.
temporary allotment, anytime it's okay, you can take it back. But then you have to compensate him, isn't it?
Exactly,
What-
Lordship.
Exactly. After receiving instruction. However, Your Lordship, as per the minutes of the meeting, we can see that permanent structure has been put up, Your Lordship, and that is the main reason why, Your Lordship, that district administration has taken action that that should be removed, Your Lordship, because as per the agreement, just as the petitioner has
It
read
is
out,
only
it
for
is
the
for
water
temporary.
reservoir.
Yes, but however, as per the minutes one, we can see that like permanent structure has been put up, Your Lordship. So I think a verification has to be done whether that thing has been done or not. And as far as the agreement is concerned, Your Lordship, we have to see after obtaining instruction, Your Lordship, what recourse has to be taken, Your Lordship. That can be decided after instruction.
Yes, Lordship. In the meantime, I have an interim order because 9th October is the deadline given, Lordship. And now, if this court has not given an interim order, then the violation of rights under Article 21, right to livelihood and right to access to water, which is also covered under Article 21, will be affected, Lordship. Then this will again give rise to multiple litigation, Lordship. So in the meantime, during the pendency of this case, Lordship, I'm impugning 3 orders. That is decision taken on 9th April 2025. Temporary allotment site, termination of temporary allotment site dated 17 April
And the notice.
2025. Then another notice, Lordship, dated 15th April 2025, Lordship. Now, this can be kindly suspended or stayed, Lordship, at this juncture It will in no way prejudice the case of the respondents, Lordship.
Your Lordship, as far as 9th October, which is going to be decided, Your Lordship, the petition is saying it is going to prejudice the case, Your Lordship. How, Your Lordship, minutes of the meeting one, Your Lordship, if you can kindly see. Minutes of the meeting, page 42, one, Your Lordship. And notice will be served to Mr. Wabang Temjin to remove all the permanent structures within the government acquired land on or before 9th of October. Your Lordship, it is relating only to the permanent structure, Your Lordship. The action is going to take only with regard if there is any permanent structure without, Your Lordship. So I think giving an interim on this, Your Lordship, may not help also, Your Lordship.
Lordship,
Because we have to
No,
see,
but
it's only
if
for
the council is ready to argue, then I'm
Till the
willing
matter
to.
is decided,
Yes,
I think
Lordship.
we will have to.
Yes,
stay.
Lordship. If she's ready to argue, the matter is now ready, Lordship.
This petition under Article 226 of the Constitution of India has been filed by the petitioner, praying for quashing and setting aside of the impugned meeting minutes of 9th April 2025 and the termination of temporary allotment site, termination of temporary allotment dated 17 April 2025 and the notice dated 15 April 2025. Stop. Learned counsel for the petitioner, Ms. Nityo Rizal. Stop. It is the case of the petitioner that the respondent number 4 had allowed the petitioner to construct a water reservoir to supply water to the jail inmates and residents of the MU colony, MU colony, Mokokchung. Stop. An agreement dated 8th of November 2012 was also executed between the respondent number 4 and the petitioner. Stop. It is stated that the petitioner had built a water reservoir on the allotted site and he had been supplying water to the jail inmates as well as to the colony residents. And many people are depending on it for sustenance. And this has also become the source of livelihood for the petitioner and many other unemployed persons. Stop. However, without considering the above, the land allotted to the petitioner for the water reservoir was arbitrarily cancelled and another notice was issued by the respondents directing the petitioner to dismantle the structures constructed in the allotted site. The temporary allotment granted to the petitioner was also cancelled. Stop. Issue notice to the respondents returnable within 4 weeks. Stop. The learned government advocate, Ms. Livika, has accepted notice for all the respondents and hence no formal notice is called for. Stop.
My objection to the interim may be reflected, Your Lordship.
Yes. The petitioner shall supply extra copies of the writ petition to the learned government advocate during the course of the day. Stop. The learned government advocate has objected to the prayer for the interim order at this stage on the ground that what did you say? The ground that
Your Lordship, effective on that 9th October, Your Lordship, it is only to remove all the permanent structures. Your Lordship.
the notice to the petitioner was only for removal of the permanent structures which was built within the allotted land on or before 9th of October 2025. And therefore, there is no reason for this court to stay the said notice. Stop. However, in the interest of justice, this court is of the view that the impugned orders need to be stayed till the matter is finally decided by this court.
Your Lordship, it can be till the next returnable date, so that at least on the next date.
Accordingly, the meeting minutes dated 9th April 2025 the termination of temporary allotment dated 17 April 2025 and the notice dated 15 April 2025 shall remain state till the next returnable date. So please, Dr. Forbes. Yes.
Obliged, Your Lordship.
For motion, item number 34.
May I please, Lordship?
Yes.
Lordship, this instead with petition is filed for appointment on commissioner ground, Lordship. Her Lordship,
You are a married woman.
no,
This
Lordship,
one,
I'm
is
the
it this
son.
one? Oh, the
I'm the
son.
son of the,
Okay, okay. When did your father die?
27/03/2025, Lordship.
Usually the department keeps a list in
Yes,
chronological
Lordship,
order.
I've annexed it, Lordship. Annexer G series. Page 27, Lordship.
Page.
27, Lordship. I've obtained an RTI reply from the department, and if the Lordship may kindly go to page number 35, Lordship. Under Longling division, the petitioner is at serial number 3. Under Longling, the petitioner is at serial number 3, Lordship. But Lordship,
You are at serial number 3, yes.
Lordship, but there is an error in that list because if we go through the serial number 2, Lordship, his father expired on 09/05/2025, whereas my father expired on 27/03/2025. And the application was submitted by the one who is at serial number 2 is at 12/06/2025, but I have submitted on 21/04/2025. So I should be at serial number 2, Lordship.
What about serial number 1? Serial number 1 also submitted on 11/5. Oh, that is 23.
Yes,
Okay,
yes,
23.
So here my prayer is to kindly consider the case of the petitioner for appointment on commissioner ground, Lordship.
That they will consider, the scheme is already there,
Lordship,
but the only thing is the serial number. They have to follow the serial number.
Lordship.
No,
I should be at serial number 2, Lordship.
where have you stated that? You in your pleadings?
Para 5, Lordship. Page 6, Lordship. That the petitioner obtained a copy of the RTI reply from the Director of Health and Family Welfare, Nagaland, Kohima, dated 27/08/2025, containing the list of compassionate applicant and the list of appointed compassionate applicant till that under the department. Therefore, under the RTI reply, the present petitioner is serial number 3 under Longling division. As per the RTI reply, my name is at serial number 3.
Okay, yes, this one, I think we can dispose it off on the next date. You just get instructions regarding this, okay? Because see, the petitioner had submitted his application on 21/4 and his father died on 27/3. Whereas the person at serial number 2 submitted his application on 12/6. You got my point?
Lordship.
So just clarify from the department and then this court will give a direction to put him in serial number 2 if that is the case, okay? And then we can dispose it of. So yes, learned counsel for the petitioner, Mr. Such and such. So the case of the petitioner is that the petitioner's father died in harness on 27/3/2025 while rendering service as MTS under the establishment of the medical superintendent, District Hospital Longling, Nagaland, leaving behind the petitioner's mother along with his 4 siblings, among which the petitioner, you are the eldest.
Lordship.
Among which the petitioner is the eldest, yes, stop. Upon the demise of his father, the petitioner submitted a representation praying for appointment on compassionate ground under the office memorandum number AR-8/8/78 dated 17/9/2015. Stop. The petitioner submits that according to the list compiled by the department for compassionate appointment, his name appears at serial number 3 in the under the Longling division. Stop. However, according to the petitioner, his name should have been at serial number 2, as the person who is at serial number 2 had submitted his application only on 12/6/2025, whereas the petitioner submitted his application on 21/4/2025. Stop. Moreover, the petitioner's father expired on 27/3/2025, whereas the father of the person at serial number 2 expired on 9/5/2025. Stop. The petitioner has therefore approached this court, praying for. But in your prayer also, you have not stated anything about that. Only praying for compassionate appointment. For that, you'll even if you're at serial number 2, you have to await your turn.
Lordship.
Yes. So, praying for compassionate appointment under the establishment of Medical Superintendent, District Hospital, Longling, under the scheme of compassionate appointment. Stop. The petitioner has also prayed for placing him at serial number 2 in this list as mentioned above. So, issue notice 2 weeks.
3 weeks, Lordship.
Issue notice returnable within 3 weeks. Stop. On the next date, the learned government advocate shall obtain instructions. Learned government advocate such and such shall obtain instructions, and an endeavor shall be made to dispose of the matter on the next returnable date. So the learned counsel for the petitioner shall supply extra copies of the writ petition to the learned government advocate during the course of the day. So list after 3 weeks.
For motion, item number 35.
May I please, Lordship?
Hmm.
Lordship, this matter is also pertaining to appointment on commissioner ground.
Hmm.
Here, Lordship, page 49 of my petition, Lordship, RTI reply. Under Longling division, she is at serial number 1, Lordship. Atoli, the present petitioner, under Longling division, she is at serial number 1. And she is the wife of the
Deceased.
Lordship, who expired on 21/05/2022.
Learned counsel for the petitioner, Mr. Such and such, to the case of the petitioner is that the petitioner's late husband died in harness on 21/5/2022 while rendering service as driver under the establishment of the Directorate of Health and Family Welfare, Nagaland. Stop. The petitioner had submitted a representation praying for compassionate appointment under the office memorandum number AR-8/8/78 dated 17/9/2015. When did you submit your application? On 29/8.
Lordship, they have not inserted the date in the first representation, Lordship. Page 25 of my petition, Lordship.
Okay, what did I say last night? Okay. However, despite the passing of more than 3 years after her husband's demise, the petitioner's representation has not been considered by the state respondents till date. Being aggrieved, the petitioner has approached this court, praying for compassionate appointment. Stop. Issue notice returnable within 4 weeks. The learned government advocate, Mr. Sen himself, accept notice on behalf of the state respondents, of all the state respondents, and therefore no formal notice is called for. So the learned counsel or the petitioner shall supply requisite copies of the writ petition on the learned government advocate during the course of the day. So please stop the votes. Yes.
For motion, item number 36.
May I please, my lord.
Yes.
Lordship, so many times we preach about gender equality, non-discrimination on the ground of sex, women empowerment. However, we are many a times not animated by the gospels that we preach. Here is also a case where despite no bar being made under the state's policy for appointment of married women on compassionate basis. The petitioners.
No, it depends. A married woman, if dependent on the deceased father,
Yes,
that is okay. But if she is not dependent,
yes.
and if she's married and she's dependent on her husband, then I don't think it's possible.
Now,
Yes.
she was a dependent,
Hmm.
my lord. And in fact, the department also,
Hmm.
are also wanting
Hmm.
perhaps to
Help.
accommodate the petitioner.
Mm.
However, it is the Department of Justice and Law's opinion that, my lord, which I have annexed in the which is mentioned in the
Hmm.
impugned letter at page 50.
No, but you have to show to the department that
Yes, those
that
things-
your
yes.
husband is unemployed
Yes, my lord,
and
my lord,
dependent
my lord.
and all.
Yes, my lord. Now, when compassionate appointments are made, the files are being, after approval by the concerned department, it is being put up to the PNR. PNR's approval is mandatory, it is required. So PNR sought the advice of the Justice and Law Department, asking whether a married woman can be considered for compassionate appointment.
Mm.
Now, the opinion given by the Justice and Law Department is based on a decision of the Honorable Supreme Court, which is reported in 2021 12 SCC, though only the name of the case has been mentioned in the impugned letter. It is a compassionate appointment dealing with the state of Karnataka. Now they have a peculiar scheme. Under their scheme, married women are not to be considered for appointment on compassionate basis. There is a specific part.
In
Now, in that case, that part also was not challenged, which is why the hands of the court was also tied, since there was no challenge to the part, and it was ruled that married women cannot be considered. However, there are a sea of judgments, a catena of decisions.
No, that's why I'm saying it
Which says
depends
that-
on the
yes, yes,
dependency.
My lord, my
Mm.
lord, my lord. I have mentioned some of the cases.
Where's the impugned order? Let's see.
The
The impugned.
letter is at page 50, my lord.
You're talking about this Directorate of Treasuries
Yes, my lord.
versus.
My lord. I have reproduced the ratio in paragraph 12. I have reproduced the relevant paragraph. Now, under that rule 3, 1996 rules, only unmarried and widowed daughter shall be entitled to or eligible for the appointment on compassionate ground in the case of a deceased female government servant. Whereas under the Nagaland government scheme, there is one is spouse, two is son,
And then
daughter. Yes, there is no criteria on the basis of marital status. Now, even if it is a son or even if it is a daughter, if it can be shown that he or she was dependent on the
deceased employee who died in harness. Didn't compassionate appointment.
But after getting married, normally you are living in a separate household,
Yes, ma'am.
isn't it?
Yes, my lord.
And how can, normally speaking, how can a married woman be dependent on the father? That is
Now,
that question.
now
is also-
we can very well make that same
We'll see,
argument
we'll see.
for a son also.
We'll see. We will not examine. Yes. Also for the petitioner, Mr. Sitiana, stop. The case of the petitioner is that the petitioner's mother, oh, it was the petitioner's mother, not
Yes,
the
madam.
father. That the petitioner's mother died in harness on 10/1/2021 while working as laboratory assistant at Fazil Ali College, Mbokchung, under the Higher and Technical Education Department, Nagaland, Kohima. Stop. It is stated that she was the sole breadwinner of the family. Stop. Being faced with financial difficulties, the petitioner had submitted an application for appointment on compassionate ground on 28/7/2021, but the same was not considered. Stop. Hence, the petitioner had filed WPC 332/2021 before this court, which was disposed of by the order dated 6/12/2021, directing the state respondents to consider the petitioner's representation within 2 months. Stop. However, the petitioner's application was rejected by the impugned letter dated 12/5/2022. And-
My lord, 9/6/2022 is only a covering letter.
So 12/5/2022, and we'll say 12/5/2022
My lord.
on the ground that she is a married woman. Stop. The learned counsel, learned counsel for the petitioner submits that in the scheme, we have enclosed the scheme,
Yes, my lord.
page.
Next 13, my lord.
That in the scheme formulated by the state government, by the state of Nagaland, White Office Memorandum Number AR-8/8
Page 42, my lord.
/78 is dated 17 September 2015. No differentiation has been made between the married woman and unmarried woman, married daughter and unmarried daughter. Stop. At paragraph 2, at this paragraph 2 of the said office memorandum dated 17 September 2015, it is stated that the appointment on compassionate ground shall be given only to one of the following members of the deceased employee's family dash A, spouse, or B, son, or C, daughter only. So in view of the aforementioned scheme /OM dated 17 September 2015, the petitioner is praying for a direction to the respondents to consider and appoint the petitioner on compassionate ground to any grade 3 or grade 4 post. Stop. Notice return within 4 weeks. Stop. Donald Government Advocate such and such has accepted notice on behalf of all the respondents, hence no formal notice is called for. Stop. The learned counsel for the petitioner shall supply extra copies of the writ petition to the learned government advocate
In the course of the
within
day.
the course of the day, during the course of the day. Stop. This after 4 weeks.
CP of life, ma'am.
For admission, item numbers 1 to 9.
May I please, your lordship.
Yes.
Lordship, your pleadings are completed, your lordship. If this matter may be listed on Monday, your lordship. 13.
I have not.
Somewhere I saw an order that a writ appeal is pending or something. Is it this case? Yes.
Yes.
After 3 weeks on the ground,
687.
on the ground that issues similar to the issues involved in this batch of writ petitions are pending before the division bench. So that is disposed,
No, lordship.
not disposed. Then Can we take it up without disposal of that writ appeal?
For that decision will have a bearing in this case
Hmm.
also, Lordship. So,
Yes, government advocate, what do you say?
Lordship is behalf of Valley Sangam.
Hmm.
Today is our station.
Hmm.
So, but the state is already filed it.
No, no. Pleadings are complete, no doubt. But whether the single bench can take it up when the similar matter is pending before the division bench? That is the question.
Lordship, then let it be listed after the disposal of the witnesses, Lordship.
Or what we can do is we'll list it after a week and then let them also get the instructions.
Lordship.
Hmm.
Then on Monday, Lordship.
Since the council who's appearing is
Yes,
not
Lordship. On Monday, Lordship.
Monday.
One.
The Senate Council, Ms. Esther is present for the petitioner. Mr. L.T. Sanctum, additional AG, is not present today as he is in court number 2 or absent.
Lord, he is out of station.
As he's out of station. So Plenary Council, Mr. Santiago
Appears
appears
for
for
response,
spot
1, 2,
number
and 3 in all the cases.
1, 2, and 3 in all the connected cases. So, as the learned additional AG is not present today, list the matter again on Monday, 13th. Yes.
For admission, item number 13.
Yes,
The bleedings are completed. What I made of the this.
hearing. We'll put it in hearing, normal course. It is stated by the learned counsel for the parties that the pleadings are completed. So accordingly, this is the matter for hearing in usual course.
Yes, and there.
The interim order passed earlier shall continue till the next date.
For admission, item number 42.
Yes, Your Lord.
Yes.
I am challenging the present ongoing recruitment of the excise department. Before going into the records, Your Lordship, the brief facts is that the excise department usually in their in their recruitment, they have only 2-tier recruitment, that is physical test and then viva.
Viva.
That was the settled practice in the department. For the present recruitment, also they brought out the advertisement that the 2-tier system will be followed. However, subsequent to the advertisement, in the middle of the process, they have brought out another corrigendum saying that they are going to conduct the written examples. Further, there is also one memorandum which has been brought out by the Department for Physical Tests, which clearly lays down the tests that are to be applied for in the physical. Even that has been violated. So on 2 main grounds, I am approaching this honorable court for challenging the validity of the process which is going on. Now I'll take the lordship to the records. Annexure A is the, since it starts with the annexure, with the administrative approval for recruitment, and annexure A at page 28. And the type copy is at page 29. This is the administrative approval for recruitment for uniform service. Now it reads like this: with reference to the above cited subject and your letter number so and so, I am to convey the approval of the government to the draft advertisement notification for recruitment of 40 numbers of excise constables to departmental recruitment board. In this regard, you are directed to set up a departmental recruitment board at an early date prior to issuing the advertisement for recruitment. Now it is very clear, the recruitment board is to be set up first before advertisement for recruitment is to be made. Furthermore, that to ensure that the directives given in the meeting minutes held on so-and-so on recruitment of uniform service, copy enclosed is adhered to. This has the clearance of the P&AR department, why so-and-so, so-and-so. So this is the approval. Now the advertisement, Roger, this is Annexure B. Advertisement is stated 7th of April 2025. April 2025. As if I may read, as per the approval of the government of Nagaland, white letter number so-and-so, dated so-and-so, March 2025.
Yes.
Dated the 4th March 2025, Kohima, the 25th March 2025, applications are invited from the indigenous inhabitants of Nagaland in the manner prescribed below. Item number 1, 40 posts of excise constables, non-gazetted, male and female. Criteria and requirements. 1. Educational qualification, class 8 pass. This is very important, class 8 pass. This is as per the service rules. 2. Age limit, 18 to 38 years as on 1st April 2025. Now, as per the service rules, it is between 25 to 18, as per the service rules. But here, the government has made some relaxation, so this has been allowed up to 35 years of age. 3. Minimum height is so-and-so, so-and-so. Recruitment process. A, this is important. Physical test. B, suitability test, viva watching. So these are the only 2 tests which are to be applied. Issue of applications forms, so-and-so. So the others, what I'm basing my case on is this test. That is recruitment process, physical test, B,
and
suitability test. Now, Roger. There are the tests as examples of the earlier reviews. I have annexed Annexure C1 and C2. These are exactly the same as the present advertisements. Annexure C1 is the type copy is at page 32, the next page. Here also.
Physical test and
Yes, 2 tests. Physical test, B, suitability test. The next advertisement, that is C2, page 34. Same, physical test and suitability test only. This is the settled practice of the department. So accordingly, the present advertisement was also made. Now, one other important violation is Annexure D, Lordship. This is the memorandum which was issued by the copy is at page 37. Page 37, page 36 is the original copy, which is not very clear. Page 37. This is the memorandum on how to the criteria for physical tests. So in this, the other specifications are there, but what I am going to stress on is the actual exam that is to be conducted. So page 38, it is also it is quite clear in page 38.
Dated.
This is dated 19/7/2016. The signature is it is March 20. 16, but but the signature was but it was issued on 19/7/2016 by the then Commissioner of Excise.
So here, what is relevant?
This paragraph 3. All the others, they are to be conducted, medical tests and all are to be conducted, but what I'm aggrieved with is paragraph 3, the violation of paragraph 3. Paragraph 3, which is at page 38. The typed copy is at page 39, but the page 38 is very clear. Paragraph 3. Those candidates who meet the prescribed physical standards as specified will be put through physical efficiency tests as indicated below. Male and female, and then A, 100 meters race. The timing is 16 seconds for males, 18 seconds for the females. B, 800 meters race, 3 minutes, 4 minutes for females. C, long jump, 3.5 meters, 3 chances are to be given to males. 2.75 meters, 3 chances are to be given to the females. D, high jump, 1.05 meters for the males, 0.90 meters for the females. And E, shot put, that is for the males only. So these are the tests which are to be applied in the physical test. Now, subsequent to the advertisement and contrary to the first directive which is contained in paragraph 1, paragraph A, annexure A, that the Departmental Recruitment Board be first set up prior to the issuance of the advertisements. This advertisement was issued first, and subsequent to that, on
Advertisement
25th March,
7th April.
yes, 7th advertisement was on 7th April, and then on 25th of March 2025, annexure E1, which is type copy is at the next page, that is page 41. Original is for page 14, page 41. So approval for setting up Departmental Recruitment Board was issued by the government. Now, I am also agreed with this, especially with the Constitution. The date, it is optional. It is peripheral, in fact, but it was also in violation of the annexure A. With reference to the subject cited above, I am directed to convey the approval of the government for setting up of Departmental Recruitment Board for recruitment of 40 posts of Excise Constables, grade 3. 1. Commissioner of Excise, Chairman. 2. Representative of the BNAR, member. 3. Representative of Finance, member. 4. Representative of Law and Justice, member. 5. Representative of Administrative Department, member. 6. Additional Commissioner of Excise, member, secretary. So these are the 6 members of board members who have been approved to constitute a Departmental Recruitment Board. Now I am aggrieved with these 6 because as per the service rules, this is contrary to the service rules. So the first thing is, it was only issued subsequent to the advertisement. Secondly, the number of persons that have been made as members, it is contrary to the service rules. I'll come to the service rules later on. Okay?
Yes.
Now, the next page, that is annexure E2, this is the notification whereby the approval was given effect to. That is
For the board.
Yes, this is 23rd of April, 2025. So I am agreeing with an approval as well as a notification, annexure E2, E1 and E2. These are included.
Regarding the date, I think there's not much dispute because,
Yes, but
because it
regarding,
is-
but the setting up of the
uh,
board members, I am more concerned with the number of.
the
persons that-
constitution, the
Yes,
constitution.
yes, constitutional. Now, annexure 8 is the service rules. This is the extant service rules. Now here, I'll take your lordship to page 46, which deals with recruitment.
Hmm.
1. Recruitment to the service. Oh, I'll take note, yes. Yes. Recruitment to the service after the commencement of this rule shall be by any or all the following methods. A, by direct recruitment through competitive examination selection. Only it is a generic kind of term only. It does not specify that it should be this, these are the process. So it is very anomalous, and based on this, they have made it a practice to have only physical and viva, because that is more important. This is constabulary. So you need fit individuals. Fitness is more important. B, by promotion of members of the services having put in minimum years of service as prescribed in Schedule 4. Then 2, notwithstanding anything contained in sub-rule 1, if in the opinion of the government, the exigencies of the service so require, the government may, in consultation with the commission, adopt such methods of recruitment to the service other than those specified in the said sub-rule, as it may by order issued in this behalf be prescribed, provided that the quota allotted to each source of recruitment under clause A and B of such rule. 1, and the minimum educational qualifications and conditions for recruitment shall be as mentioned in Schedule 2 and 3. Now, educational qualifications and conditions for recruitment shall be as mentioned in Schedule 2 and 3. Now, the government has enhanced the age of the candidates. I'm not so much aggrieved by that, but still then, as per the service rules, the service rules is very clear as to the, even to the age group, who should be considered for appointment in this case. Now, the government, if it deems it fit that the present process which is being adopted is to be changed, it must do so in consultation with the commission. The commission is the NPSC. Because there are two methods of appointment. In the case of recruitment, in the case of constables, it is done by the department. In the case of
Gazetted.
yes,
Gazetted officer.
inspectors, it is through the NPSC. But generally, it has been by clause 2 of Rule 5. It is made clear that if the government wants to make changes, it must do so in consultation with the board. That means the commission, that is not the board, but the commission, NPSC. So it has to not the board, but the NPSC has to be consulted, and if any changes are to be made, the government may do so. The rule, they have made it in such a way that it is the NPSC which must be consulted. And only after that, the government may direct the authorities to include whatever tests that the government wants. It is not the board's. The board has no power to
According
change the
to you-
existing rules.
According to you, only the
Yes.
government in consultation with the
Yes,
commission.
with the
can-
commission, yeah. Not the board.
Mm.
It is very clear.
Okay.
Now. Constitution, number 7, rule 7, page 47. Constitution of
Yes.
Constitution of Selection Interview Board and Departmental Promotion Committee to non-gazetted posts. 1. Selection for direct recruitment and promotion to the posts of Assistant Inspector of Excise, Head Constable, and Excise Constable shall be made by a board committee consisting of the following members. Number 1, Head of the Department, Chairman. Number 2, Representative from Administrative Department, Member. Number 3, Representative from BNAR Department, Member. Number 4, an officer nominated by the Head of Department from the Director as the Member Secretary. So these are the only 4 members who shall constitute the recruitment board. So long as this is not amended, it cannot be, nothing can be changed. No members can be added to this. That is my position. Because the service rules are very clear. Only when the service rules is not very clear, when the service rules does not make these specifications, the government may, the administration may supplement the law by making its rules, but it cannot supplant the service rules. That is the simple position of the law. It cannot supplant. Now, if there were any provisions for written interviews and all, the service rules would have made it very clear. Now, if your lordship may go to the schedule 5, this is page 57, schedule 5. Syllabus. These syllabuses are made for
This is for.
for promotion only. If they had intended to have a written examination, then the syllabus for that written examination would have been made here. There is no provision. It only talks about only for those higher promotions. So to interpret that written examination is inherent in the rules, that kind of interpretation cannot be done, which the present selection board is trying to infer. They are implying that it is implicit in the rules. That written examination may also be included as part of the interview process, but no, the rules never intended for written examination conceivable. That is why there is no syllabus. Syllabus ought to be there. And if at all, written examination is to be introduced, it is to be introduced by the government. By a specific notification or a notification, and thereafter syllabus has to be determined prior to the interview process, not in the middle of the interview process. At least the rule 5 makes room for changes, but that is to be made only by the government, not by the selection board or by the department head. The government has to decide it, and then everything has to be clearly laid out before the interview. But here, in this case, that has not been done, and the rule does not contemplate for a written examination. This is what I want to emphasize by showing that
syllabus is there only for promotional examinations, not for recruitment examinations. Now, the Lordship Annexure G. And addendum, this is all right because it is the inclusion of 6 posts, extra posts. I'm not agreed by this. But the Annexure H is the improved order, corrigendum. It's the type copy is at page 64. Page 63 is Annexure H, the original, which is not very clear. So type copy, if I may read.
Yes.
This is the board's decision. This is to inform all concerned that in continuation to the advertisement number so and so, dated Dimapur, 7th April 2025, and addendum number so and so, dated 14th May 2025. The Departmental Recruitment Board decided to include written text in the interview process for the post of 46 constables of excise in line with other uniform services. This is in the month of June. This is dated 4th June 2025. This is obviously without any authority vested in the selection board to make.
This is June, so
June.
Advertisement was
in March.
April.
April, you're right.
Advertisement was 7th
7th of
April.
April. 7th of April.
So after the last date of
Yes,
submission of
everything was completed, then when the process was to, when the actual physical test and all, everything was to be conducted, started, they came out with this. Now the order dated 2025, this is only regardment to no change of nomenclature. Departmental Recruitment Committee shall be changed to Departmental Recruitment Management Committee. Now, apart from the recruitment board, they have also set up one departmental recruitment management committee for the physical test. So that the order, by this order that the recruitment committee was brought up. But it is, since it is just a process of looking after the physical test, I'm not agreed by this. They just to show that this is the process which is going on in the department. Now, by this Annexure 1.3, I3, page 67, the recruitment committee submitted some grievances before this recruitment committee, which is management committee, which has been set up. They submitted some issues before the recruitment board which needs to be addressed, which is at page Annexure I3, page 67, but 69 is the type copy, which is clear. Page 69, if I may read. Oh, I'm sorry. It's no type copy has been provided. I'll read it. If I'm page 67.
Page 67.
Yes. This is addressed to the Chairman, Departmental Recruitment Board, Excise Department. Ongoing recruitment process of 46 excise constables. Sir, with reference to the above cited subject, we, the members of the Departmental Recruitment Committee, would like to put forth the following views on the decisions arrived at in the second TRP meeting held on so and so June 2025 for the greater good of the departmental recruitment process. that there has been a major decision to make the examination process as 3-tier exam from the 2-tier exam by inserting a written examination after a lapse of almost 2 months from the time it was first advertised in the print media as a 2-tier examination process is baffling and leaves a lot of room for unwarranted complaints, criticisms from various quarters and legal action. So far, in any recruitment process, it is unprecedented and unheard of that middle course of a recruitment process, the core structure of the examination process is altered and deviated from the original structure that has been widely publicized in the media through an advertisement. That it was decided to stick to the examination process as a 2-tier examination in the first TRB meeting on 29 April 2025 as advertised in the local dailies, and suddenly the decision to make it into a 3-tier examination in the second TRB meeting on 2nd June 2025 is causing unnecessary controversy as it involves giving delayed information to the candidates, which will also require providing sufficient time to the candidates to seriously prepare for the change patterns of the examination process. Syllabus content, which will have to be circulated to the candidates, question paper setting, examination hall preparation, etc. are important logistical arrangements which will require time for preparation and will track and make the examination process protracted and exhaustive in nature. Inclusion of written tests is a drastic deviation from the normal recruitment drive undertaken by the department in the last 2 recent recruitment or in the history of the department with regard to recruitment of constabulary. 6. Physical test is the primary test for a field personnel and therefore the majority of marks must be allotted to the physical test. As per norms, all decisions have to process in files, but such was not undertaken with respect to this decision. 8. The time duration for a physical test is too short and practically impossible to conduct physical tests for around 10,000 to 11,000 applicants will require a minimum of 10-15 days, including the buffer days for weather rainy days, which are beyond our control. Unfortunately, in the ongoing recruitment process, there has not been any consultation or inputs thought even on the agenda of the GRB meeting. Rather, the undersigned are kept in the dark on most of the major issues pertaining to the recruitment process. We are of the opinion that since the execution and conduct of the recruitment process on ground have been entrusted to the GRC, it is imperatively important that decisions reflect ground reality and keeping an appropriate feedback system alone will help make the recruitment process a success. So there were some issues which were raised by the recruitment special committee looking after
The physical test.
yes, these are just the internal communications, but these things were also raised. Now, next year, Chief, this is the representation submitted by 2 candidates. The present two petitioners at petitioners number petitioner number 6 and 13. Petitioners number 6 and 13 submitted this representation immediately after the corrigendum was issued. This is addressed to the Chairman Departmental Recruitment Board, Excise Department, Government of Nagaland. If I may read.
Yes.
Respected sir, we, the undersigned, have the honor to bring forth this humble petitioner representation before your biennial authority for your kind consideration necessary order as we pray hereunder. We are the poor candidates hailing from interior villages and none of us have government employees in our family. As such, we are underprivileged group of people who seek the mercy and grace of God to avail means for livelihood. It is pertinent to say that there are thousands of people who are facing the same difficulties being unprivileged group of peoples in our state. At this juncture, we came to know the advertisement for recruitment to the post of excise constable under the following criteria and requirements. 1. Educational qualification class A pass. Age limit 18 to 38 years. 3. Minimum height. So and so. Recruitment process. A. Physical test. B. Suitability test. Viva voce. Accordingly, we have submitted our biodata as a candidature for the same post. As such, the department has issued acknowledgement slip admit cards to join the recruitment process as per the advertisement dated 7th of April 2025. After preparing for the recruitment process, we have learned from some reliable sources that there will be written tests for the recruitment process against the criteria of the notification. It is not the criteria for recruitment of constables in the past recruitment process because there are several number of constables that have been appointed under the criteria of 2 tiers, that is physical test and suitability test, viva voce, and they have been performing their diligent duty to the satisfaction of the department. It is pertinent to state that when the criteria of 2-tier test is requisite qualification, criteria to the said post, why the new system of 3-tier or of test to the same post, which qualified by the government department by conducting 2-tier of test. It is logical conclusion that while we are bound to go for written test, it means forceful imposing to the poor persons like us who could not get proper education how to write and read in the village level. The motive behind of the new policy may presume that rich people to be richer and poor people to be poorer by giving restricted criteria to the underprivileged like us. That if the department is fair and justice in the eye of law of equality before law, why the same pattern of 2-tier pattern test to our case? A. Physical test and suitability test. B. To appoint to the post of constable like before, which the department had recruited and appointed to the post of constable. Therefore, justice and equality before law under Article 14 means measure same yardstick to the same situation in this subject matter. We, the undersigned, underprivileged, and helpless candidates are approaching before you and before God that a fair and justice shall prevail in the process of recruitment to the post of constable by giving fair and justice to the poor people like us by allowing us to face tests of physical tests and suitability tests without imposing the written test, which is in the written criteria of within criteria of recruitment process. If failing which, thousands of underprivileged poor people may raise their voice to redeem their demand in future, which the department will be able to for justice and fair to us. It is therefore most humbly prayed that your pioneer authority may look into this matter as a genuine and urgent in nature, thereafter consider to allow the 2 veteran days for recruitment to the post of constables as we pray for. This is 12th day of June 2025. So their grievance they have raised that the written days should not be imposed. Now, subsequently, this 2 of the present petitioners, that is petitioner number 1 and 2. Petitioners number 1 and 2, they submitted an application under RTI for asking for the following. Number 1, a copy of the existing service roles. Number 2, copies of the past advertisement for similar recruitment published since 2016 up to date. Number 3, the marking system consistently applied in selection in the past, that is percentage of marks assigned for physical test and percentage of marks assigned for suitability test, viva voce. 4, marking system to be applied in the present selection, that is percentage of marks assigned for physical test, written test and viva. And 5, the copy of the entire file noting related to the present recruitment. What is going on in the department in order to ascertain that? Now, by the page 73, which is annexure L, the reply was furnished. So type copy is at page 74. This is 4th July 2025. The presidential, the 2 petitioners' application was on 12th June 2025, and 4th July 2025, the reply was furnished. With reference to your, sir, with reference to your application seeking information under RTI Act 2025, I am to furnish the following information in abstract relating to the advertisement, to advertisement number so and so, copy enclosed in annexure 8. This is for your kind information. Now, RTI reply, the next page. It's not very clear, that is why a typed copy has been provided at page 76. RTI reply, number 1, copy of the existing service rules enclosed. 2, copies of the past advertisements for similar recruitment published since 2016 up to date, copy enclosed. 3, the marking system consistently applied in selection in the past, that is percentage of marks assigned for physical test and percentages of marks assigned for suitability test, no marks for physical test, and Viva Voce 12%. That is the system they have been applied. 4, the marking system to be applied in the present selection, that is percentage of marks assigned for physical test, written test, and Viva Voce. Physical test, no marking. Written test, 100 marks, that is the present exam which is to be held, and then Viva is 12. Then all the copies of the entire file noting related to the present recruitment copy enclosed. So the following pages are the file notings, Your Lordship. Now here in this file noting, some interesting, fascinating facts are to be found, which I'll take your notes here to page 100. This is the typed copy at page 100.
As a senior,
Yes, this is a senior officer. As a senior directorate officer and as a member of the Departmental Recruitment Committee of the present recruitment process, the following observations are made as the minutes of the TRB for consideration by the authority so as to ensure and facilitate the smooth execution of the recruitment process. 1. First and foremost, without a marking or scoring pattern in the physical test, we simply cannot arrive at a ratio of intake for the suitability test. Understandably, the TRB could not give a figure of the ratio. In the absence of marking system, we will not be able to zero down on a ratio, and that will be a logistical nightmare for the conduct of interview with the near possibility of extending the interview period for several weeks. As the recruitment advertise is for both male and female candidates, it would have been proper that a decision on the number of posts for female candidates should have been minuted for clarity on the matter. Authority may, as the chairman of the TRB, may kindly give due consideration on the above pertinent points. As clearly explained, noted in page 11 and 12 above, the Department Recruitment Committee may set up by the HOD, who is also the chairman of TRB, and in spite of the same, the views, opinions of the TRC has been put in vain. It may be suggested that the committee may be revoked or cancelled so that there is no room for difference and the TR board can execute according to their minutes. Now, again, another page 102. The above observation made by the officers and members of the Departmental Recruitment Committee on the minutes of the TRB are self-explanatory, and unless addressed, it will create a lot of difficulty in the entire recruitment process. As members of the TRC duly constituted by the authority, dated 14 April 2025, it is of utmost concern for us to ensure that the entire recruitment process goes smoothly without any hitches. Therefore, as the chairman of the TRB, it is requested that the minutes of the TRB may be revisited for greater good and positive outcome of the examination process. Now, 1, 2, 3. So these are, these processes were going on with regard to what is going on, even the officers have not been, the ARC, that is the committee, were not even properly briefed, or they were not even given proper guidelines as to how to proceed. And they have been making these grievances, that these things need to be addressed, and all these were just not even considered as per the office notice. Their grievances, all these have been raised. Now, there was one. Oh, yes. There is page 97. Roger, this is has been page 97. This is just as it is. It was there in the file. The meeting, if I may, the meeting minutes of the Department Recruitment Board is found to be deficient and not in line with government order notifications and practices. One, whereas only 40 posts were advertised, but serial number 1 of the minutes mentioned 46 posts, and addendum to the inclusion of the additional 6 posts need to be advertised first. Number 2, WRD, the physical standard test, there is, with regard to the physical standard test, there is an order signed by the then C. Maria Yandal, that is the memorandum.
The previous
Yes,
memorandum.
yes. Where benchmark for running, long jump, etc. were specified. However, the DRB have overlooked all such criteria and set arbitrary benchmark for
Not consistent.
not consistent with the standing order. 3. Furthermore, when there is only 2 tests, physical and viva voce for selection of candidates, physical test being the primary test should be given primacy as is the practice with all other exams. However, it is observed that marks was allotted to viva voce, but the primary test is not allotted any marks. The same yardstick should apply for both the tests. If there is no marks for physical tests, so also there should be no marking for viva voces. In the same way, if marks is given to viva, so should physical test as well. In all exams, the primary test is given the maximum weightage for shortlisting of applicants for interview. For instance, in NPSC, the primary test is 600 marks and viva is 55 marks. In NSSP, the primary test is 200 and interview mark is 10. This clearly highlights a pattern where viva voce mark is less than 10% of the total mark. Likewise, for meritocracy to prevail, mark should be given to physical test and viva voce mark should not be more than 10% of the total marks. 4. The age limit is also inconsistent and cherry-picked, whereas the lower age limit of 18 years is as per service rules of the department, but the upper age limit of 30 years is based on government order notification. We should adhere fully with either one or the other. The age limit as per service rule is 18 to 25 years. The age limit as per government notification is 21 to 38 years. Given the above inconsistencies, that DRB meeting minutes may need to review and suitable amended so as to avoid complications in the future. So all these complications, they have been internally going on, and with regard to the physical test, even this was brought to the notice of the board. It's already in existence, but here the board was also intimated about the memorandum is there. It should be asked for the memorandum. The board decided to go as it pleased without considering all these issues. Now, I'll take your lordship to the last representation which was submitted. This was submitted before the physical test began. It was to be conducted within a few days. So the petitioners submitted this representation to the department. We have highlighted the grievances here. Sir, this is stated, I'll take the
120, page 120.
Yes, page the 9th of July 2025, page 120. 9th July 2025. If
So here also you have stated about the board constitution.
yes, all these.
And then you have stated about the two-tier system and the three-tier system.
Yes,
Good under the terms.
and also. And
then regarding the physical test.
and also the physical test, that the physical test should be conducted as per the
As per that memorandum.
memorandum, which is fair test. So that the place should be selected, that is our position.
So now what is the status? Now they have all appeared for the
The
physical
written
test.
examination, the written examination was conducted, the selection, even with regard to the physical, no particular result was given, how they did the physical test, it is not the result sheets are not available with us, but they conducted the physical test. In the physical test, only three tests were applied, contrary to the. I have. Since this petition was filed after the commencement of the physical test, we came to realize that the board is not going to go by the
OM.
Yeah, as per the OM. Paragraph 20, page 20. Okay? Page 20. From day one, all these violations began. That is why we knew that our continuing in the process is not going to help. So 20, that the physical test began on 14/7/2025 and shall continue till 24/7/2025, since this petition was filed in the middle. All the petitioners except the petitioner number 4, who shall be appearing on 24/7/2025, appeared at test, expecting that the physical test would be conducted in terms of the memorandum dated 19/7/2016. But to their surprise, the tests applied were lower than those prescribed by the memorandum. Only the following tests were applied. 1. Running 800 meters. 3 minutes. Female 4 minutes. 2. Long jump 12 feet 3 attempts. 10 feet 3 attempts for male and female, that is. 3. Pull up 10 times for the men and 0.5 times for the females. So these were the only 3 tests which were applied. So now realizing that this entire exam is a farce, the petitioners were compelled to approach this honorable court by way of this writ petition. In the middle, while the physical test was still going on. So this honorable court was pleased to, in the interim, direct that whatever exams, the process will be subject to the outcome of the writ petition.
So now it's completed.
So
the
no,
recruitment process.
the results are not out.
No doubt.
No doubt. The written examination was conducted anyhow. Subsequent to this, they have brought out, after we filed this writ petition, they brought out some modifications for the written examinations, which are in the
counter affidavit.
Counter affidavit. We one notification. Here are. There was one particular notification saying that it will be class 8 standard. Somewhere during the middle of the, after, just before this. But yes. Page 19, huh? Yeah, Lordship, well, see there, this is a not annexure 5. Annexure 5, page 18 of the affidavit in opposition. The type copy is at page 19. This notification was issued dated Dimapur, the 25th July 2025. That is subsequent to the filing of the present rate case. So here, notification. With reference to the State Excise Department, advertisement number so and so dated 7th April 2025, addendum dated 14th May 2025, and correctional dated 4th June 2025, and subsequent physical test conducted from 14th to 24th July 2025 at DDSC Stadium, Dimapur. The list of candidates who have qualified for a written examination will be available in the department website. And in the notice board of the Commissioner of Excise Officer, Office Dimapur, Nagaland, the written examination for the qualified candidates will be held on 9th of August 2025 in different examination centers as shown below. Number 3, the written examination shall carry a total of 100 marks. The question pattern shall be MCQ question with no negative marking and based on class 8 standard. The duration of the written examination shall be 2 hours from 10 a.m. to 12 noon. 4, candidates should produce the original provisional admit card, without which they will not be allowed to appear at a written examination. 5, no further calling letter and no new admit card will be issued for a written examination. So they are making up things around the simple as that. In the earlier corrigendum, nothing was mentioned about what kind of examination it will be. It will be a written examination. Now, by this notification, they have again introduced the concept of class 8 standard. This is how they are going along. No syllabus is prescribed, nothing. Class 8 standard, it will be MCQ, 100 marks, all this. These are clear changing of the goalposts as along the way. So now, with regard to the changing of the goalposts, that is the introduction of the written examination.
After the
advertisement, after the process has started, because the process starts with the advertisement, and the most recent judgment of the Supreme Court only I shall remember. 2025 to SCC, 2025 to SCC on the earlier of this standard. Yes, I think that is 2025 to SCC. This is Ditch, Prakash Pathak and others versus Vedasan High Courts and others. So I'll take your lordships to the relevant principles which are to be discussed. Paragraph 22 to 28 first. Paragraph 22 to 28. Page 20.
Commencement,
This is
commencement, end of.
commencement of the recruitment process, when it commences. 22.
Hmm.
The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. It consists of various steps like inviting applications, scrutiny of application, rejection of defective applications, or elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of lists of successful candidates for appointment. Basis of the doctrine. D. 23. The doctrine prescribing change of rules midway through the game or after the game is played is predicated on the rule against arbitrariness enshrined in Article 14 of the Constitution. Article 16 is only an instance of the application of the concept of equality enshrined in Article 14. In other words, Article 14 is the genus, while Article 16 is a species. Article 16 gives effect to the concept of equality in all matters relating to public employment. These two articles strikes at arbitrariness in state action and ensures fairness and equality of treatment. They require that state action must be based on valid, relevant principles alike to all similarly situated and not to be guided by any extraneous or irrelevant considerations. In all its actions, the state is bound to act fairly in a transparent manner. This is an elementary requirement of the guarantee against arbitrary state action, which Article 14 of the Constitution adopts. A deprivation of the entitlement of private citizens and private business must be proportional to a requirement grounded in public interest. 24. The principle of fairness in action requires that public authorities be held accountable for their representations. Good administration requires public authorities to act in a predictable manner and honor the premises made or practices established unless there is good reason not to do so. 25. Candidates participating in a recruitment process having legitimate expectation that the process of selection will be fair and non-arbitrary. The basis of doctrine of legitimate expectation in public law is founded on the principles of fairness and non-arbitrariness in government dealings with individuals. It recognizes that a public authority's promise or past conduct will give rise to a legitimate expectation. This doctrine is premised on the notion that public authorities, while performing their public duties, ought to honor their promise or past practices. The legitimacy of an expectation can be inferred if it is rooted in law, custom, or established procedure. 26. However, the doctrine of legitimate expectation does not impede or hinder the power of the public authorities to lay down a policy or withdraw it. The public authority has the discretion to exercise the full range of choices available within its executive power. The public authority often has to take into consideration diverse factors, concerns, and intense interests before arriving at a particular policy decision. The courts are generally cautious in interfering with a bona fide decision of public authorities which denies legitimate expectation, provided such a decision is taken in the larger public interest. Thus, public interest serves as a limitation on the application of the doctrine of legitimate expectation. 27. Courts have to determine whether the public interest is compelling and sufficient to outweigh the legitimate expectation of the claimant. While performing a balancing exercise, courts have to often grapple with the issue of burden and standard of proof required to dislodge the claim of legitimate expectation. 28. In Sivanandan CD, the Constitution Bench, speaking through one of us, Dr. D.Y. Chandrachud CJ, held that for a public authority to frustrate a claim of legitimate expectation, it must objectively demonstrate by placing relevant materials before the court that its decision was in the public interest. This standard is consistent with the principles of good administration, which requires that state action must be held to scrupulous standards to prevent misuse of public power and ensure fairness to citizens. It was also highlighted that the doctrine of legitimate expectation lays emphasis on predictability and consistency in decision making, which is a facet of non-arbitrariness. In addition, the court observed that The underlying basis for the application of the doctrine of legitimate expectation has expanded and evolved to include the principle of good administration. The principles of good administration requires that the decisions of public authorities must withstand the test of consistency, transparency, and predictability. These are tests which, in the present case, no consistency, no transparency, and there is no predictability in the process which is being adopted here. To avoid being regarded as arbitrary and therefore violating of Article 14. Paragraph up to 28, now 35 and 36. This is dealing with one particular case, but which makes things quite clear. 35, the discernible ratio in K Manchushir is that the criterion for selection is not to be changed after completion of the selection process, though in absence of rules to the contrary. The selection committee may fix minimum marks either for written examination or for interview for the purposes of selection. But if such minimum marks are fixed, it must be done before commencement of selection process. This view has been followed by another 3-judge bench of this court in Ramesh Kumar versus High Courts of Delhi, where the law on the issue has been summarized. Thus, 15. In case the statutory rules prescribe a particular mode of selection, it has to be given strict adherence accordingly. In case no procedure is prescribed by the rules and there is no other impediment in law, the competent authority, while laying down the norms for selection, may prescribe for the days and further specify the minimum benchmark for written days as well as for viva voce. That means even if the rule does not clearly say any benchmark that is to be set, though they may do it, it has to be done before the selection process.
Specific.
Yes, it has to be specified. 36. What is important in K Manchushri is that the minimum marks for the interview was fixed after the interviews were over. In that context, it was observed that the game was played under the rule that there was no minimum marks for the interview. Therefore, introduction of the requirement of minimum marks for interview after the entire selection process consisting of written examination and interview was completed would amount to changing the rules of the game after the game was played. And B, if the interviewers had to proceed on the basis that there were minimum marks to be secured in the interview for being considered for selection, and that the marks awarded by them would have the effect of barring or ousting any candidate from being considered for selection, the awarding of marks might have been markedly different. Now, 43 to 43, 49 onwards. 43 first, Your Lordship. Paragraph 43. On the other hand, in K Manjushri, the eligibility criteria for placement in the select list was changed after interviews were held, which had a material bearing on the select list. Thus, Subhash Chandra Marwaha dealt with the right to be appointed from the select list, whereas K Manjushri dealt with the right to be placed in the select list. The two cases therefore dealt with altogether different issues. For the following reasons, in our view, K Manjushri could not have been doubted for having failed to consider Subhash Chandra Marwaha. Now, 49 onward. This is with regard to viva and the written examination, the importance. So, paragraph 49. The ultimate object of any process of selection for entry into a public service is to ensure the best and most suitable person for the job, avoiding patronage and favoritism. Selection based on merit, tested impartially and objectively, is the essential foundation of any useful and efficient public service. So open competitive examination has come to be accepted almost universally as the gateway to public services. It is now well settled that while a written examination assesses a candidate's knowledge and intellectual ability, an interview test is valuable to assess a candidate's overall intellectual and personal qualities. One is objective, one is subjective. The first one, that is the written examination, is a subjective one. 50. While written examination has certain distinct advantages over the interview test, there are yet no written tests which can evaluate a candidate's initiative, alertness, resourcefulness, dependableness, cooperativeness, capacity for clear and logical presentation, effectiveness in discussion, effectiveness in meeting and dealing with others, adaptability, judgment, ability to make decisions, ability to lead intellectual and moral integrity. Thus, the written examination assesses the man's intellect. An interview test, the man himself and the twain shall meet for a proper selection. So here, in the present case, in the case of the wider the person's personality, how he can interact with others, whether he is amenable to obeying authorities or not, all these are objectively assessed. In the case of written examination, it is not so. So now, here, since this is a contemporary post, physical is number one, very important. Number two is the viva voce. That is, whether he is someone who is competent or not, because it is class 8 category. Why they have made it class 8 means only physically fit people are more important than people who are well educated. Now, because of that, the rules made it very clear, 18 to 25 years. Why? Because they want them young, smart, physically. This is why the exam was being conducted as per the rules, only the physical and the viva. Now, all of a sudden, the government decided we will allow even all these graduate and even postdoctoral students also to compete. So they have the educational qualification is class 8, but above, age-wise is 38 years now. And then educational qualification, people having even doctorate degrees. Any person can apply. And now when you apply a written examination, when you introduce it in the middle of the process, a written examination, and then giving no marks to the physical. A person may be very physically fit. A person having a higher educational qualification may barely scrape through. But still then, he is given the opportunity by the written examination. Simple as that. So this is not in public interest, but to favor certain candidates in fact. So long as the service rules is very clear, and then it is as per the service rules, not the government must, if it decides to go by the present system of introducing the written examination, it must be done beforehand, prior to the advertisement. Even the syllabus also should be laid down, which was not done in the instant case.
And even if the criteria of, even if the exam of the written exam has to be introduced,
Yes.
your case is that it has to be done only by the government,
Yes.
not by the
By the
board.
government prior to the advertisement itself. Because the service rules clearly say so, prior to the examination interview itself, because the selection process, once it starts, it cannot
be changed.
It cannot be changed. You cannot change the rules along the way. As simple as that. It cannot be changed in the middle of the process or even subsequently. In short, that is the law. Now with paragraph 51 onward, if I may. What is clear from above is that the object of any process of selection for entry into a public service is to ensure that a person most suitable for a post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its methods, procedure to select a candidate most suitable for the post, albeit subject to the overarching principles enshrined in Article 14 and 16 of the Constitution, as also the rules state statute governing service and reservation 52. Thus, in our opinion, the appointing authority, recruitment authority, competent authority, in absence of rules to the contrary, shall devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. It cannot be done in the middle of the process. But if the extant rules or the advertisement inviting applications empower the competent authority to set benchmark at different stages, here in this case, no such provision is there of the recruitment process, then such benchmark may be set any time before that stage is reached, so that neither the candidates nor the evaluator, examiner, interviewer is taken by surprise. 53. The decision in K. Manjushri does not prescribe setting of benchmarks for various stages of the recruitment process, but mandates that it should not be set after the stage is over. In other words, after the game has already been played. This view is in consonance with the rules against arbitrariness enshrined in Article 14 of the Constitution and meets the legitimate expectation of the candidates, as also the requirement of transparency in recruitment to public services, and thereby obviates malpractice in preparation of select lists. Paragraph 54. As already noticed in section A, a recruitment process inter alia comprises of various steps like inviting applications, scrutiny of applications, rejection of defective applications, or elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of lists of successful candidates for appointment. Subject to the rule against arbitrariness, how tests or viva voce are to be conducted, what questions are to be put, in what manner evaluation is to be done, whether a shortlisting exercise is needed, are all matters of procedure which, in absence of rules to the contrary, may be devised by competent authority. Often, advertisements inviting applications are open-ended in terms of these steps and leave it to the discretion of the competent authority to adopt such steps as may be considered necessary in the circumstances, albeit subject to the overarching principles of rule against arbitrariness enshrined in Article 14 of the Constitution. Now, paragraph 58. Paragraph 58. Similarly, in Tritik Kumar Dhingal versus State of West Bengal, it was held that shortlisting is permissible on the basis of administrative instructions, provided the action is bona fide and reasonable. The relevant observation in the judgments are extracted below. The contention on behalf of the state government that written examination was for shortlisting the candidates and was in the nature of elimination test has no doubt substance. In it, in view of the fact that the reports disclosed that there were about 80 posts of medical technologists and a huge number of candidates, approximately 4,000 applied for appointment. The state authorities had therefore no other option but to screen candidates by holding written examination. It was observed that no recruitment rules were framed in exercise of the power under the proviso to Article 309 of the Constitution, and hence no such action could be taken in our opinion. However, even in absence of statutory provision, such an action can always be taken on the basis of administrative instructions for the purpose of elimination and shortlisting of huge number of candidates, provided the action is otherwise bona fide and reasonable. This is all done with reasonableness. Shortlisting, that means written examination, it has been already advertised. And but nothing is said in the advertisement that the written examination will be for shortlisting. So after the examination is held, in order to administrative instruction, shortlisting may be done. These kind of minor things can be done, but then at the advertisement itself, written examination is already there. So based on that, you can adopt certain things which is reasonable. But in the instant case, advertisement does not say anything about a written examination. In the middle of the process, written examination has been introduced. And then they are making up rules alone. These are changing the goalposts. Along the way.
Okay, anything else?
Now, with regard to the administrative instruction, paragraph 62, since I'm also talking about, I'm also raising the issue of the office memorandum. This is the administrative instruction. Paragraph 62. There can therefore be no doubt that where there are no rules or the rules are silent on the subject, administrative instructions may be issued to supplement and fill in the gaps in the rules. In that event, administrative instructions would govern the field provided they are not ultra-virus the provisions of the rules or the statute or the constitution. But where the rules expressly or impliedly cover the field, the recruiting body would have to abide by the rules. Now, administrative instruction, that memorandum is an administrative instruction. It is filling up the gaps in the service rules. So it is already there. It has to be followed. It is now the rule that is to be followed. So now, with regard to the, I also take your lordship to another Supreme Court decision, which is about this is also to do with the changing of the rules along the way. Paragraph 5 and 6 of this is 2001 10 SEC, page 51. Page 51, paragraph 5 and paragraph 5.
2001, 10 SEC.
Yes. Paragraph 5 and 6. Okay. But I'll emphasize more on paragraph 5 because it talks about changing of the rules in the middle and on the after the selection. 5. If I may read. The serious dispute and controversy relates to the claim of the corporation that circular number so and so, dated 24/6/1996, only came to be issued by way of clarification, and it was not only necessary to be issued, but also governed the selection of drivers in question. The writ petitioners who were unsuccessful asserted that it is a circular dated 4/4/1995 which should govern the selection, and consequently the selection ought to have been made by assigning 87 1/2% marks for written trade test and 12 half mark for the oral test personal interview. And results declared. Accordingly, on going through the above circular orders, we find that the procedures for recruitment of drivers is separate from recruitment for other categories, where within this trade test has been specifically laid down, and that it is only where the written test and interview are stipulated, the percentage of weightage for written test interview has been resolved by the board under the directions of the state government to be fixed at 87.5% and 12.5% respectively. The direction of the state government in this letter dated 2/1/1995 only fixes the weightage to be given to the marks obtained in written test and those in interview, and no reference is found there of any trade test or written test. The resolution of the board dated 21/3/1995 also seems to be on the same lines and is with reference to marks obtained in written tests and interview respectively and not otherwise. Apparently, in view of the above, and in the absence of reference to driving tests or other trade tests too, that the corporation claims to have issued circular order number so and so dated 24/6/1996 on the basis of the earlier circular dated number 5218 for past and driving tests to be presented to the city committee and number so and so 1990 pertaining to award of marks in the interview by fixing the average of the marks awarded by the ST subcommittee to be the final and deciding factor in the matter of selection of a candidate. Therefore, the High Court cannot be said to be correct in holding that the circular order dated 24/6/1996 is illegal or arbitrary or against the orders of the state government or the resolution of the Board of the Transport Corporation. Instead, this is what I want to emphasize. It would have been well open to the High Courts to have declared that the criteria sought to be fixed by the circular dated 24/6/1996 as the sole determinative of the merit or grade of a candidate for selection long after the last date fixed for receipt of application and in the middle of the course of selection process, since in this case the driving test was stated to have been conducted on 27/11/1995, cannot be applied to the selection under consideration and challenged before the High Court. It has been repeatedly held by this court that the rules of the game, meaning thereby that of the criteria for selection, cannot be ordered by the authorities concerned in the middle or after the process of selection has commenced. Therefore, the decision of the High Court, to the extent it's pronounced upon the invalidity of the circular order, does not merit acceptance in our hand, and the same are set aside. So, I'm just emphasizing on the fact that process starts, it cannot be changed in the middle or even after. That is the clear case. Now, with regard to with regard to the rules, when the law says something is to be done in a certain manner, it has to be done in that manner. That judgment I would like to submit, because the service rules are very clear. The service rules with regard to the constitution of the board is very clear. It has to be done in that manner. When the rules are very clear. So also when the memorandum is already there, it has to be applied. That is what I want to emphasize about. This is 2011-10 SCC 714. Paragraph 32, page 725, paragraph 32.
Paragraph 32.
Yes, paragraph 32. It is settled law that when any statutory provision provides a particular manner for doing a particular act, the said thing or act must be done in accordance with the manner prescribed, therefore, in the act. Merely because the parties concerned were aware of the acquisition proceedings or served with individual notices does not make the condition altered. When the statute makes it very clear that all the procedures modes have to be strictly complied with in the manner provided therein. Merely because the landowners failed to submit their objections within 15 days after the publication of notification under Section 4(1) of the State Act, the authorities cannot be permitted to claim that it need not to strictly resolve it to. So when the law says clearly that it has something needs to be done in a certain manner, it has to be done in that manner also. Here in this case, the service rules clearly says that this is the number of members who are to constitute a quorum. It has to be done in that manner. Secondly, the memorandum. Secondly, memorandum clearly lays down that these are the physical tests which must be applied. 1, 2, 3, 4, 5. It has to be done in that manner. You cannot water it down. You cannot change it, but the board cannot change it. The board has changed the whole thing. So here, in this case, there have been clear violations by the board without any authority vested in it. It has changed the procedure along the way. Even the board is itself illegal. Board itself is
Not as
an
per
illegal
the
board because it is not as per the service rules. Now it has completely overturned the entire selection process, and so the selection process is unsustainable. So my prayer, and I have made very clear prayers and paragraphs, and I had at page page 24.
Your prayer is to set aside the constitution of the board,
Yes,
then to set aside the physical test
yes,
and to reconstitute the selection board and to conduct the recruitment process afresh.
yes. In simple terms, that. In terms of the advertisement. And in accordance with. I think that is my humble submission before the submission.
Yes, should we continue with two?
Yes.
Yes.
May it please my ladyship, but my lady, may kindly turn to page 13 of my affidavit in opposition.
Paragraph.
Page 13.
Page 13.
Yes. This is the meeting chaired by the Honorable Chief Minister. Here, minutes of discussion held on 16/9/2024 in CMRC on recruitment of uniformed services. The meeting was chaired by Honorable Chief Minister and the meeting was attended by Honorable Deputy Chief Minister, Home, Honorable Minister EFCC, Honorable Advisor Fire Services, Home Guards, Prison, Excise, DGP, ADGP, Administration, and Principal Secretary, PNAR. After deliberation, the followings were decided. 1. Decision applicable to all uniformed services. 1. Each department shall set up the respective departmental recruitment board with representative from the administrative department, PNAR, finance, and law department. So, Lordship, on 16/9/2024, every department was directed to set up the DRB with the representative of administrative department, PNR, finance, and law department. And accordingly, page 12, this is the circular, 19 September 2024. This circular has been circulated to all the concerned department to initiate necessary actions and as per the decision taken in the meeting. So in compliance to this circular, the government, my lady may turn to page 41 of the read petition. This is the type copy, page 41. Page 41, this is dated 25 March 2025. Approval for setting up departmental recruitment board. With reference to the subject cited above, I am directed to convey the approval of the government for setting up of departmental recruitment board for recruitment of 40 posts of excise constable. 1. Commissioner of Excise Chairman. 2. Representative of PNAR member. 3. Representative of Finance member. 4. Representative of Law and Justice member. 5. Representative of Administration Department member. 6. Additional Commissioner of Excise member secretary. So here the date is important, 25 March 2025. This is before the advertisement was published. The advertisement is at page 30.
Advertisement is 7th
7th
April.
4 2025. So before the advertisement, we advertise, we have the government has already approved for constitution of the DRB.
Okay.
And as per the page 47, as per the service rule, rule 7, though the DRB, we have included 3 more departments, that is the finance,
Finance,
finance and the law and justice department. But that does not in any way prejudice the petitioner. Yes, just because the addition of the finance department and the law and justice does not prejudice the petitioner. And the petitioner could not show before this court as to how, by the inclusion of the finance department and the law and justice, their rights have been violated, Lordship. Then my lady, may kindly turn to page 30, the advertisement.
Page 30 of the
Yes.
petition.
The criteria and the requirements, point 15. Serial number 15. It says any omission or commission will be rectified through notification and addendum. So advertisement also clearly mentioned that if there is any addition or corrigendum or addendum to be made, it will be made. Then number 16 also, it clearly says that in the event of any disputes on recruitment process, the decision of the department recruitment board will be final and binding. Then if you read along with the service rule, the service rule clearly provides for the written examination. Page 46, Rule 5. Rule 5.1. Recruitment to the service after the commencement of this rule shall by any or all the following methods be A. By direct recruitment through competitive examination selection. So what do you mean by direct recruitment through competitive examination? Competitive examination includes written tests.
No, but that has to be specified in the advertisement. That has to be specified because in the advertisement, it only says,
So yes,
yes,
initially when the
physical
advertis-
tests and, yes,
physical test and
Viva
suitability
and
test.
Viva.
But if we read at point number 50, it says that any omission or commission will be rectified through notification and addendum. So accordingly at
See, in all fairness,
Yes.
before the exams begin, any
Yes.
candidate,
Mm.
they always prepare in advance.
Yes.
So they have to be given that opportunity
No,
to prepare, prepare for the written
yes,
test.
for that matter, all these things has been started prior hand only before the physical test, because the physical test conducted from 14 July, and all these were done in the month of April, May, and June, before the physical test was conducted. So sufficient time were given to the candidates to prepare.
And even the syllabus that has to be specified in the advertisement.
Yes.
Yes.
So for that matter, also we have published in the notified in the newspaper. All those things has taken place before the physical test was conducted. So Lordship may take to page 64. This is the corrigendum. This is the type copy. 4 June 2025. Corrigendum. This is to inform all concerned that in continuation to the advertisement number such and such dated Dimapur and addendum number such and such, the Departmental Recruitment Board decided to include written tests in the interview process for the post of 46 Constable of Excise in line with other uniform services. Hence, the candidates are asked to prepare for the interview accordingly. So, Your Lordship, sufficient time was given to them. This was published on 4th June 2025. And the physical test was conducted between 14 July 25 to 24 July 25. So the service rule, it provides for the written examination. Then if your lordship comes, my learned friend has been saying that if we want to add for the written test, we need to take the consultation from the commission, that is the NPSC, which is a misinterpretation of the service rule. That is very clear at page 47, Rule 7, Clause 2.
Rule 7, Clause
Clause 2. Rule 7, Clause 2 says, recruitment to the post of Inspector of Excise under Rule 5(1)(a) shall be made by the Commission. But here we are only concerned with the Excise Constable. So Excise Constable does not come under the purview of the Commission. It does not even come under the purview of the NSSB. So the consultation of the Commission or the consultation of the government by the recruitment board does not arise, because the service rule clearly gives the power to the
To the government. So the recruitment board is not the government.
No, it is the
Yes.
board. It is the board. Because the board has the full authority, your
Board
lordship.
Board cannot be the government.
No,
Yes,
I'm not
yes.
saying that the board is the government.
Consultation may be, consultation with the commission may be only with regard to gazetted posts. like
Gazetted
inspector and
post,
all.
yes, yes.
That is fine.
But in regard
But-
to the excise constable, the board has the full authority. They are the recruiting authority. Then page 48, rule 8, clause 2. This is the qualification. Qualification for direct recruitment for all the groups of the services shall be such as specified in Schedule 3. The Schedule 3 is at page 55. If my ladyship see,
Yes, yes.
comes to for excise constable, the educational qualification is class 8 pass.
Is that there's no dispute
Yeah.
about that.
Then my lady may turn to page 49, rule 9. The eligibility of candidates.
59.
Yes.
Yes.
Rule 9. The decision of the commission or the selection board, as the case may be, as to the eligibility or otherwise of a candidate shall be final. So it is the board who has to decide on the eligibility, the manner, the procedure as to how they are to be selected. So the rule itself gives powers to the DRB. So the
Eligibility as in Rule 9
yes,
would be with regard to their educational qualifications, etc.
yes, etc. Yes.
So that is okay.
Yes.
And I think petitioner also has no dispute regarding that.
Then with regard to the rule 5 of direct recruitment through competitive examination, it includes written examination. So my lady may come to page 64, where the board has notified that the selection were to be page 64. This is to include the written test in the interview process.
This is the impugn order.
Yes.
Yes.
Then at page 19 of my affidavit in opposition.
Page 19.
This is the type copy, page 19. We have notified that point number 2, the written examination for the qualified candidate will be held on 9th of August in the different examination center as shown below. Then number 3, the written examination shall carry a total of 100 marks. The question pattern shall be MCQ question with no negative markings and based on class 8 standard. The duration of the written examination shall be 2 hours from 10 a.m. to 12 noon. So all these things we have make it transparently known to the petitioners. And even the petitioners they sought for RTI, and in our RTI reply, we have clearly mentioned that is at page 73 of the petition lordship. '74 is the type copy. The RTI replied to the petitioner, page 74, for July 2025, to such and such, subject reply to RTI, sir. With reference to your application seeking information under RTI Act 2025, I am to furnish the following information in abstract relating to advertisement number such and such, copy enclosed in Annexure A. So the next page, page 75, the type copy is at 76. At 1, a copy of the existing service rule 2. Copies of the past advertisement for similar recruitment published since 2016, up-to-date copy enclosed. 3. The marking system consistently applied in selection in the past, percentage of marks assigned for physical tests and percentage of mark assigned for suitability tests. No marks for physical tests and viva voce 12%. The marking system to be applied in the present selection, that is percentage of marks assigned for physical tests, written tests and viva voces. Physical test is no marking. Number B, written test will be 100 marks. Number 3, viva voce will be 12 marks. So, this was done on 4th of July 2025. We have given the reply to the petitioner on 4th of July 2025, which we have given prior to the conduct of the physical test. So the petitioners and even the other candidates are also well informed prior to the conduct of a physical test. And the petitioner also could not show in what manner the addition of the 2 members in the DRB, as well as the introduction of the, not the introduction, the implementation of the written examination as prescribed in the service rule has affected the fundamental rights. They could not satisfy this court, Lordship. Rather, Lordship, the intention and the object of the DRB in implementing the written test as prescribed by the service rule is to have a fair examination with no bias, with no nepotism, and with no favoritism. Because we have seen in so many of the constable recruitment process, many favoritism and nepotism have taken into place, and corruption has also taken into place. So the implementation as laid down by the service rule is to have a fair and transparent examination.
See, in previous years, you have only conducted physical tests and
Yes,
viva
yes,
all throughout the years.
yes.
So there is a logical reasoning
Yes.
that even this year it will be written and physical and viva.
Yes.
So the candidates have prepared themselves accordingly. So when the advertisement is issued, it is assumed that it will be like the other years. But suddenly, in the midst of the recruitment process, you have introduced this. That is their grievance.
Yes.
Yes.
It's because yes.
So I think the government should have put that in the advertisement. If that was the intention at all, should have put it in the advertisement itself.
No, so in the
That the
advertisement,
written test will also
we
be
have clearly
conducted.
mentioned in category number 6, serial number 15, that if there is any omission and commission on the part, that will be notified in the subsequent. So the advertisement clearly provides for that. And just because in the earlier occasion we have not followed, does not debar or prohibit the
No, of course, it's
department.
up to the government.
Yes.
To adopt any method of recruitment.
Yes.
That goes beyond saying. But still, at what stage can you put in that
So,
change?
Your Lordship, even the Supreme Court also, it clearly says that when in the constable examination, when there is only provides for suitabilities and viva voce, the government should prescribe
No,
for written examination.
that is okay. You
Yes.
can provide any mode of recruitment. That is fine. The government has the power to go for any mode of recruitment. But what the Supreme Court says is after and the process of recruitment starts from the advertisement.
Start from the
Starts from the
advertisement and ends with the appointment.
Mm.
So what if my learned friend he's relied on the 5 judges bench. Instead of supporting his case, that judgment supporting the government case. It's very clear. I'll show you, Lordship. It's very clear because in that one it says it talks about the criteria. The eligibility criteria cannot be changed in the middle of the selection process because once eligibility criteria is changed, then a person who wants to compete in the exam on the earlier occasion could not apply. But here in our process, the physical test has not started. before the physical test started, we have informed all the candidates. So we have not changed the rules also. And we have notified all the documents as per the service rule. Lordship. And even my learned friend, he has read so many file notings to show as to how there is an arbitrariness or whatever. But a file noting cannot be relied on unless it has culminated into an order or by a notification. So those are just internal communication. Those should not be taken into consideration.
That is just to show that the department people themselves were not happy with the.
No, it shows that some of just of the record, but that shows that people must have been having their candidates also. Lordship, I may be allowed to read some of my paragraph. Page 4. Para 9.
Yes.
Page 4, para 9. That with regard to the statement made in paragraph 11 and 12 of the writ petition, the DRB decided to include written examination so as to conduct an impartial and fair recruitment and give equal opportunity to all candidates. As such, the department issued corrigendum dated 4/6/25, informing all the candidates about the written test in the selection process for the post of 46 Constable of Excise in line with other uniform services, which was widely published in the daily newspaper in Nagaland Post and Eastern Mirror. The Departmental Recruitment Management Committee was constituted to assist the DRB and Department for smooth conduct of the recruitment. The physical test was conducted from 14/7/2025 to 24/7/2025 by the DRB in consultation with the DRMC representative. Therefore, the question of the MRC in that does not arise. Then, that with regard to the statement made in paragraph 13 and 14 of the writ petition, the deponent states that the DRB had included the written examination as part of the recruitment process within the scope of what is permitted under the Nagaland Excise Service Rules 1999, whereby it has been provided in Rule 5.1. Recruitment to the service after the commencement of this rule shall by any of the following methods, viz. A, by direct recruitment through competitive examination selection. The service rule impliedly allows the recruiting authority, that is DRB, to design the selection process, including written test, physical test, biography, suitability test, and any combination as long as it is fair and reasonable. The DRB has included the written examination within the framework of the rules. The department by notification dated 25/7/25 has notified that the written examination will be based on MCQ pattern carrying 100 marks based on Class 8 standard, which is in compliance to the minimum educational requirement as notified in the advertisement dated 17/4/25. Further issuing a corrigendum to notify a written exam is legally valid as it's aligned with the existing recruitment rules. Corrigendum was issued before the start of any assessment. Sufficient time was given for the candidate to prepare, and it equally applies to all candidates. Prior government approval is not necessary as the service rule already provide for competitive examination. As such, the entire procedure was done to ensure fairness in the selection of excise constabulary. The introduction of written examination does not put the petitioner in any disadvantaged position as the syllabus for the written examination was decided to be based on Class 8 standard, and more so because the question patterns were to be MCQ questions only. In fact, the introduction of written examination eliminates the opportunity of any bias of favoritism or nepotism in recruitment. Hence, the allegation of the petitioner that the introduction of the written test is to benefit rich people and deprive the poor is totally erroneous and misconception of just and fair recruitment intended by the deponent authority. So, Your Lordship, by implementing of this, we are to ensure that the recruitment is fair and just, so that there is no manipulation. With regard to the Supreme Court also clearly says that in regard to the recruitment of the constable, the prescription of written test may be prescribed. That is at 2025 7 ACC 705. This is State of Assam and others versus Arabinda, Rabah and others. This is a case of Assam constable of forest. My lady, may kindly turn to paragraph 39. Paragraph 39. Yes. It cannot be gainsaid that the factors of when, which, what, who, and how that are associated with a recruitment selection process is the prerogative of the recruiting authority and the selectors. However, at the same time, the process has to be conducted consistent with statutory provisions governing the same, if any, as well as principle of absolute fairness and complete non-arbitrariness. Though it is true that the law does not postulate a fetter on the authority of the employer, state, and it is within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in the absence thereof. It is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidates aspiring for appointment have to pass through in order to be placed in the select list, who would be the selectors, and how weightage is to be given to each of the testing methods. A great deal of credence is lent to a process if it is fairly and transparently conducted in accordance with rules, whatever be its source, without the slightest hint of any bias or favoritism or nepotism. Normally, it is not for the courts to interfere unless the process smack of mala fides. However, the right to be considered for public employment being a fundamental right, it would be safe and prudent to have recruitment rules to govern the process of selection so that the best possible talent is appointed in public service. Obviously, assigning the merit of the candidates aspiring for public employment on the basis of a prescribed standard would not only provide a level playing field for each of them, the excellence of any institution to which the appointment is to be made would depend directly on the proficiency of its member staff, and that would in turn depend on the quality and merit of those who offer themselves for selection and ultimately get selected, necessitating the selection to be conducted without any hidden thing or marks mala fide. Last but not the least, having regard to present times, when corruption has been held to be a walk of life by certain responsible citizens of the country, it would have been desirable if the process of recruitment of 104 constables were conducted after framing of recruitment rules and also prescribing a written examination to keep the process absolutely above board. Then, Lordship may turn to page para 44. It is further useful to remember that the government itself felt that the selection being entirely based on interview, the same admitted an element of arbitrariness, and that the assessment of candidates being based merely on the basis of marks at the interview was reasonable for drawing a presumption of being misused for favoritism, and could well be regarded as suffering from the vice of arbitrariness. In such circumstances, it is indeed difficult, if not impossible, for a court of law to substitute its decision for the one taken by the government, reasoning that the selection has not been challenged by any unsuccessful candidate. So, Lordship, here also the Supreme Court clearly says that unless the process is met of mala fide, it is not for the court to interfere. And even, Lordship, in my affidavit in opposition, we have clearly categorically stated that only the physical test and the viva vocis would attract arbitrariness. So when that is the position raised by the court,
it's completely up to you. You can
Yes.
include the written test if you
Yes.
want. Okay, the court is not saying anything on that. But at what stage can it be put in? That is the only question.
So for that here, it will be suffice here. 2025 to ACC Supreme Court 1. Here, that will answer your query. My lady may turn to.
This is the same case which.
Yes, which he realized. So I
realized.
say that instead of helping him, it's help the state. Here para 1. Resolution query.
Para 1.
Yes. This is the reference.
Reference.
Yes. 1. A three-judge bench of this court, while accepting the salutary principle that once the recruitment process commences, the stake or its instrumentality cannot tinker with the rules of the game insofar as the prescription of eligibility criteria. Only in respect of eligibility criteria we cannot is concerned. Wonder whether that should apply also to the procedure for the selection. So it's only with regard to the eligibility criteria we cannot, but for the other procedure, for the method, the modality, we can proceed. So in that context, doubting the correctness of coordinate bench decision in K. Manjusri for not having noticed an early decision in Subhash Chandra Marhawa, White Order dated 23/2013, it was directed that the matter be placed before a Chief Justice for constituting a larger bench for an authoritative pronouncement on the subject. Whereas the 5 judges bench says that these two are different, totally different subject matter. Lordship, may kindly turn to page para 49. Para 49.
Yes. The ultimate
Yes, the ultimate object of any process of selection for entry into a public service is to secure the best and the most suitable person for the job, avoiding patronage and favoritism. Selection based on merit tested impartiality and objectively is the essential foundation of any useful and efficient public service. So open competitive examination has come to be accepted almost universally as the gateway to public services. It is now well settled that while a written examination assesses a candidate's knowledge and intellectual ability, an interview test is valuable to assess a candidate's overall intellectual and personal qualities. 50. While written examination has certain distinct advantages over the interview test, there are yet no written tests which can evaluate a candidate's initiative, alertness, resourcefulness, dependableness, cooperativeness, capacity for clear and logical presentation, effectiveness in discussion, effectiveness in meeting and dealing with other, adaptability, judgment, ability to make decision, ability to lead, intellectual and moral integrity. Thus, the written examination assesses the man's intellect and the interview tests the man's himself, and the twain shall meet for a proper selection. 51. What is clear from above is that the object of any process of selection for entry into a public service is to ensure that a person most suitable for the post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method, procedure to select a candidate most suitable for the post, albeit subject to the overarching principles as right in Article 14 and 16 of the Constitution, as also the rules, statutes governing service and reservation. 52. Thus, in our view, the appointing authority, recruiting authority, competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and while doing so, it may also set benchmark for different stages of the recruitment process, including written examination and interview. Then even my lady may turn to page the conclusion, that is at para 65.4. Yes, or I can read from 65 also to make it clear. 65. We therefore insert the reference in the following terms. 65.1. Recruitment process commences from the issuance of the advertisement calling for application and ends with filling up of vacancy. 65.2. Eligibility criteria for being placed in the select list notifies at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rules so permit, or the advertisement which is not contrary to the extent rules so permit. Even if such change is permissible under the extent rules or the advertisement, the change would have to meet the requirements of Article 14 of the Constitution and satisfy the test of non-arbitrariness. 65.3. The decision in K. Manjusri lays down good law and is not in conflict with the decision in Subhash Chandra Marwaha. Subhash Chandra Marwaha deals with the right to be appointed from the select list, whereas K. Manjusri deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. 65.4. Recruiting bodies subject to the extent rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted in transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. So these are very clear, Lordship. We have not changed the eligibility criteria. We have not changed anything. And before the physical test commenced, we have informed all the candidates that there will be a written examination. And the written examination is prescribed by the service rule. So in the action of the respondent in no manner has violated the rights, fundamental rights of the petitioner. And my ladyship, I may be allowed to place on record that may kindly come to page 5 of the writ petition. The post title. Yes, the petitioner number 1, 2, 4, 6, 7, 8, and 12. They are 12, 15, and 16. Petitioner number 1, 2, 4, 6, 7, 8, 12, 15, and 16. 15 and 16. 12, 15, and 16. 16. Yes, they participated in the physical test and they were declared fit and they even appeared in the written exam. Whereas the other petitioner, they never appeared. They never applied. They are not candidates. Yes. So, in a nutshell, the action of the respondent in Lordship is to provide fairness in recruitment process, free from arbitrariness, free from nepotism, free from favoritism. So, in none of the action has ever violated the petitioner rights. So, my prayer is that the writ petition does not warrant the interference of this honorable court. Much obliged.
Yes, any reply?
Take your lordship to that Manchushri case, which has been clearly upheld by the judgment. This is 2008, 3 502, 512. Yes. 2008, 3 SCC 512. Now, before going into this.
In fact, the Supreme Court in this Tej Prakash case did not interfere with any of them, said that they are operating in different fields.
No, with regard to this one, this was a reference to the Supreme Court. It was a reference to the Supreme
It was a
Court,
reference.
But
Yes.
the Supreme Court has gone through the entire gamut of the law. They have,
Yes.
they have discussed.
And discussed Manjushri also and that
Yes.
Subhash Chandra Marwa
Now,
also.
yes, what Manjushri says, it is not with regard to the eligibility criteria, but changing of the rules in the middle of the process. That is what I am
Okay.
emphasizing on.
Let us see.
And so paragraph 27. But what could not have been done was the second change by introduction of the criterion of minimum marks for the interview. The minimum marks for interview had never been adopted by the Andhra Pradesh High Court earlier for selection of district and sessions judge grade 2. In regard to the present selection, the administrative committee merely adopted the previous procedure in vogue. The previous procedure, as stated above, was to apply minimum marks only for written examination and not for the oral examination. We have referred to the proper interpretation of the earlier resolutions dated 24/7/2001 and 21/2/2002, and held that what was adopted on 30/11/2004 was only minimum marks for written examination and not for the interviews. Therefore, introduction of the requirement of minimum marks for interview after the entire selection process consisting of written examination and interview was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. In this case, they adopted the earlier practice. That was okay. But what happened was, they adopted something new after the process had completed. And the law is that you cannot adopt anything new before or even after. Here it is not about eligibility criteria. Even for some things like the interview process itself, some changes which is not permissible by the law. And whether the commission, whether the board has the authority to do it or not, that is also the question. With the board, what is the power of the board? Now I'll just take a lordship to the paragraph 28 also. In Ramachandra Iyer, the court is deciding so many different cases which were in which interview process stood vitiated because of changes in the rules along the way. In Ramachandra Iyer, this court was considering the validity of a selection process under the ICAR rules 1977, which provided for minimum marks only in the written examination and did not envisage obtaining minimum marks in the interview. Here. But the recruitment board, ASRB, prescribed a further qualification. Here, the board has prescribed something new, something further, which is not clearly there in the act itself, rules itself, of obtaining minimum marks in the interview also. The court observed that the power to prescribe minimum marks in the interview should be explicit and cannot be read by implication. They are trying to read by implication that the board has the authority to introduce this written examination. Whereas the rules does not explicitly say that there should be written examination. Had the rules clearly contemplated it in the schedule itself, they would have mentioned that written examination will be this much.
No, but even if the rules do not explicitly mention it, the government can use.
Not the,
yes.
Not the board. I am saying that it is not the board has no authority to do all these things. It's the government. And that also the government must make the decision prior to the interview process. That is the only case. I'm not saying the government has no power. The government has the power, but then when the service rules are very clear, then in that case, the service rules have to be applied. The administrative authority, the government may supplement the rules, but cannot supplant the laws, which is already there. Here, in this case, what they have done is the executive has sat together and decided to add some new members. But that also it is general. Here, this member of the board was laid down because in the police department and other departments, uniform services, they don't have rules. Because of that, they laid down that we must have this board. But in the case of the excise department, we have clear-cut rules already in place.
But by inclusion of the finance representative, the law representative, it does not prejudice you in any way.
The board has been making these decisions all along. That shows that something is wrong. And the board cannot do that. So now, I am aggrieved even by the violation of the rules of constituting the board. The board has to go by the rules. That is the only position I'm taking, I'm standing on. And the board is not empowered.
No, but
Here-
if the government makes a policy
So what
decision,
makes the policy
Yes.
decision, that is a different issue, because the service rules also make it very clear. The service rule says that the government may, in consultation with the commission,
no,
Make it
no,
up.
not only that, the government can make a policy decision regarding the constitution also.
that is not
Ah,
there.
that
But
is
then
all-
here in this case, I'm
that's
not
fine.
about the government policy decision. Here I am about, I am concerned with the change
That is,
after,
that is.
yes, that is the only,
is a
that is
different
the only
point.
ground I'm taking. And it is in violation of. I don't need to show that my fundamental right has been violated by this. It is, that is the law, and law has to be followed. And so in this, from paragraph 27 onward till 33 and 36, it's very clearly explained where rules, where the norms were changed along the way, even the small one. When the rules does not say, then it is not permissible under the law. And the board has no power, no authority to do that. That is my only, if the board cannot arrogate to itself powers which it does not have. And here, the board has done it. Now, your lordship, with regard to trying to explain how, what happened, how, by way of affidavit, it is not permissible. Your lordship, I'll just take your lordship to one specific judgment of the Honorable Supreme Court. This is 2013-10 SCC 95. No, 106. No. Oh, yes. 95. Yes, 95. I'll take your lordship to paragraph 16. Trying to explain things by way of filing affidavit is not permissible. Paragraph 16. Evaluate.
Yes.
The following observations found in the celebrated decision in Mohinder Singh Gill versus Chief Election Commissioner are relevant to this question. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned, that is mentioned in the order itself, and cannot be supplemented by fresh reason in the shape of affidavit or otherwise. Otherwise, an order passed in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought up. We may here draw attention to the observations. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer, making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actions and conduct of those to whom they are addressed, and must be construed objectively with reference to the language used in the order itself. So now they are trying to explain away everything by filing an affidavit and making statements in the affidavit. It cannot be done in that manner. So the simple fact is that rules have been changed along the way. It is not permissible under it. And then the statutory rules must be strictly adhered to.
Yes.
My lord, I may be allowed to clarify. My learned friend has been relying on K. Manjushri case, then that it does not cover his case, because K. Manjushri case is a distinct one. It was the fixing of the minimum marks for the interview after the interviews were over. That's why the Supreme Court says that the rule of the game should not be changed. That is clearly mentioned in 2025 2 SCC 1 paragraph 36. Paragraph 36. What is important in K. Manjushri is that the minimum marks for the interview was fixed after the interviews were over. So here in our case, before the process started, before the suitability test started, we have informed the candidates. So there is a clear distinction. So we have not changed the rule of the games while in the midst of the selection process. Then, Lordship, I may be allowed to reiterate again Rule 7 of the service rule. Rule 7 clearly says that selection for direct recruit, and we'll say selection for direct recruit to excise constable shall be made by the board. Rule 7, page 47. Rule 7, para 1. Selection for direct recruitment to excise constable shall be made by the board, consisting of the following such and such. So it is the board who has the authority, not the government. So the board has the power to prescribe as per the service rules.
No,
And
no,
only in respect-
this is for the recruitment process.
Yes,
The entire recruitment process, the board has the power.
yes.
That is fine,
Mm.
but not to change, that's what you're saying, but
That's-
not to change the
So,
rules.
recruitment number 5, the 5.1, it clearly says recruitment to the service after the commencement shall be by any of the following method. One is by direct recruitment through competitive examination. So the service rule clearly provides, does not debar the recruitment board to implement the written examination. So I want to make a clarification on this.
Constable.
So whatever we are doing is within the framework of the service rule. And we have not changed the games once the rule of the game, once the game has started. Much good.
General process for the petitioner, Mr. Tom Commoner, as well as Ms. Risha, please let know the additional AG for the said respondents. Hearing concluded, judgment is. But
For unlisted motion, item number 44.
these, no, these big ones, you just get photocopy, and this one is okay, just leave it like that, okay? Yes.
Yes, my lord. On 19th of September, then application 17 of 2025.
Yes, the order, let us see the order. Page
32.
Page
Election A.
22. Page 22. This is bail application 23.
Yes. Bill application 22 and
Yeah.
those arena is 23, monthly core is 22.
Which one have you given me? This one? Item 44 or 45? This one is item 45. Oh. Page 42.
32.
32.
32.
Two. So what happened?
We placed the certified true copy of this order in the trial court. However, the opinion in the trial court, only the verbal opinion was that no direction has been specifically given to the trial court to execute the.
See, the High Court does not take bonds. Okay,
Yes.
that is understood. High Court never takes bonds. So the execution has to be always done before the trial court.
Yes, ma'am.
So if it is, nothing is specified, sometimes we specify saying that
Yes.
to the satisfaction of the trial
Yes,
court.
yes.
But if nothing is specified, it is implied that it is the trial
Yes, my
court.
lord.
Ah,
My lord,
so,
I have also taken that same stand
yes.
in paragraph 9 and have even the citation of some landmark decisions
Mm.
on bail
Mm.
passed by the Honorable Supreme Court as well as by this Honorable Court, reported decisions, starting from Balchan.
Yes. Okay. So where's your prayer?
Well, leadership, no doubt this court has a power to pass appropriate order, however, not by way of bail application. This will
No,
amount
that's
to
what I
something-
thought,
It's
because it should be
not
a
by-
review or
yeah.
something.
No, my
Yes.
lord. I
It
have,
is to
His prayer
modify.
is to modify.
To
So,
modify.
Yes.
let me clarify.
Mm.
Firstly, under the Committee High Court rules,
Mm.
there is no particular for review of criminal applications or criminal petitions. One, because there is specific power under the Criminal Procedure Code and PNSS. Criminal orders passed by criminal courts cannot be reviewed. One. If my
It can be an IA for modification.
now
Yes.
when the
Modification of.
when the main case has already been disposed, will an IA lie that is
It can be, It
If-
because.
now my lord.
That's
allow
what I
me to-
thought also. How can it be another bail application?
Yes.
Can-
it will amount to
Because the
completely
court has
bail
already
application.
allowed.
Yes.
You
Then
are
there
only
is a
for
final technique.
modification.
Yes.
Allow me to explain,
Yes.
my lord, my understanding, because I have also thought about this for long.
Mm.
And I have done my research, I have taken in fact, opinion of some other lawyers as well.
Mm.
Now, if my lord will kindly, for section 403 of the BNSS. This is 362 under the old criminal procedure code.
Section?
403. Or 03. This short section.
Yes. Court not to alter judgment.
Yes, my lord. Save is otherwise provided by this Sanhita or by any other law for the time being in force. No court, when it has signed its judgment or final order disposing of the case, shall alter or review the same, except to correct a clerical or arithmetical error. Now, my lord, under the High Court rules,
Mm.
Page 465, my lord. For each and every class of cases, category code is provided. It starts from 457.
Yes.
457.
Mm.
With petitions, criminal appeals, criminal revisions, all this. Now,
Yes.
465, starting from 465, my lord, criminal appeals.
Criminal abuse,
Yes,
yes.
my lord. Now, 466, since this is not an appeal, for 460 criminal revisions and other cases, my lord. They have provided category code for bail applications under section 439, which is 482 in BNSS, my lord. No category code for review. It is because, my lord, in my humble opinion, it is because there is specific statutory power under the BNSS, under the CRPC, which is why no category code for review is provided. Now, my lord, this is a little tricky, the legal position. In bail matters, however, the Honorable Supreme Court has stated that review can be exercised, but it has to be by way of fresh bail application. The powers of, because the earlier bail orders, even if it is rejection or allowing a bail order, it is in the nature of an interim order. I have annexed the order passed by the Honorable Supreme Court in my petition, my lord. Page 37. Annexion 9, my lord. Ramatur Sahu versus State of Madhya Pradesh. This is a recent decision passed in 2023, my lord. The next page, page 38, my lord.
here 362, which is perimetry of 403 of the BNSS, is reproduced in paragraph 3, the top of the page. Now I may be allowed to read from paragraph 4. But paragraphs 4 and 5, I want to read, my lord.
Yes.
The opinion of the High Court in the impugn order is that in the event of High Court granted bail to the appellant without compliance of the conditions specified in the earlier order of a coordinate bench, that would constitute modification of the order, and 362, section 362 of the code prohibits such modification of a judgment or final order. Paragraph 5. An order for refusal of bail, however, inherently carries certain characteristics of an interlocutory order, in that certain variation or alteration in the context in which a bail B is dismissed confers on the detained accused right to file a fresh bail application for bail on certain changed circumstances. Now, my lord, here also.
See, for example, sometimes in the bail order, the
Yes.
court gives certain conditions which cannot be complied
Yes, my lord.
by the accused.
My lord.
So they come again for modification,
Yes,
praying for modification. Then under what provision does it come? That
Under the same provision under which the earlier bail application was filed. Even if 10 bail applications are filed, it will always be under 483 of BNSS, or before the High Court, that is, or in case of anticipatory bail under 482 of BNSS, and in the old criminal procedure code under 439 for other bail applications, and for anticipatory bail under 438 of the criminal procedure code. Now, rejecting or allowing as rejecting a bail application, it does not bar the.
no, that is fine.
Yes,
They
madam.
can always come again
Yes, madam.
if the circumstances
madam.
change.
My lord.
But here we have a case where bail is allowed.
Yes,
It's
madam.
already allowed.
Yes, my lord.
Hmm.
So when a bail is allowed or whether it is dismissed, my lord, the circumstances, lordship, it was not existing when I filed the original bail application before the bail application 17. It was only after the order was passed by this honorable court on 19th of September, and when I went down to execute the bail order, that new circumstances arose, which is why, lordship, I have approached, and when there is a change of circumstances, lordship, and my lord, at the cost of repetition. Firstly, I cannot come by way of review. Secondly, my lord, someone may give an opinion, my lord, that it has to be a petition under 428 or 482 of the CRDC, or 528 of the 23 of the BNSS, my lord. But inherent powers, my lord, it can always be exercised even without a specific prayer being made, because as the section itself says, it is an inherent power of the court, my lord. Now, secondly, when there is an option, well, if I can approach by way of 483 and 523, 28, my lord, then me being the applicant, me being the dominus litis, I can either choose. And in fact, my lord, the law is that when there is a specific provision for making an application before this honorable court, then I have to come before this court by way of that provision. Inherent powers are to be exercised only when the statute does not specifically provide, like passing off an FIR.
So I was just thinking about the possibility of 528 also.
Yes, my lord, my lord. I have also, in fact, I have spent considerable time on this during the occasion. And my lord, in fact, this may not be very directly relevant to the case. However, in Annexure 10, Supreme Court's direction issued in SMWP criminal number 4 of 2021, order was passed on 31st of January 2023. 7 directions have been issued by the Honorable Supreme Court for releasing prisoners who have been granted bail but are still under custody. In page 39, the directions are at page 41, my lord.
Those are different circumstances.
Yes, my lord.
Those are
My
different
lord,
circumstances.
But here is also a case where I have been granted bail, but
I'm still under custody. Bail was granted to me on 19th. It's already October.
I think we can treat it as a subsequent bail application under
Yes,
the
madam.
changed circumstances.
Change circumstances.
Changed
in way-
circumstances in the sense that he applied for execution of the bail
But
bonds,
that is
but
not
that
on
was not
record.
allowed.
Yes,
Yes,
the
but-
rejection, that should, the material should be on record, only then necessary order can be passed.
Lordship, we have also requested
Without
the
that,
trial court to pass necessary orders.
Necessary orders.
Yes, but it was flatly refused. I want to say only few words on this. I don't want to stretch too
just
much.
a suggestion, whether miscellaneous application, criminal miscellaneous application can be filed in the mistake.
Criminal miscellaneous application under which provision? Under which
Yeah.
category?
Category would be,
This 102 other criminal miscases.
if that can be.
Because we should not let technicalities,
Yes, my lord.
bar the accused from getting his relief.
As stated by the Honorable Supreme Court regarding Kanchan Tiri, processual law is not to be.
Other criminal cases under section 482, if there is any possibility. Otherwise, to pass an order in this bail application will set a bad precedent. What I feel is because the pleading itself shows that he is praying for modification of the order, which it has become final. So it will amount to a review.
No, Supreme Court is saying that
No, the judgment which the applicant is relying on is not at all in its favor. Because it clearly says that once the court pass an order, it cannot be
It
altered.
cannot be. altered.
Yes,
we have
it
to,
is very clear. It is not in his support.
my lord, we have to understand this bail application, keeping in mind three things. One, 403 of the PNS is one. Secondly, the category code under the Gauhati High Court Rules, two. Thirdly, the.
Because this is mainly for clarification. Your petition is for clarification.
Thirdly, the law laid down by the Honorable Supreme Court in Ramatar Sahu. That the power under, yes, the power under 403 or 362 shall not prevent a bail court from review its or modifying or altering its order. However, the manner in which I approach, it has to be not by a review petition, but by way of a fresh bail application.
I feel that 528 petition will be more proper, inherent power. Because under inherent
Now,
power,
My lord, in
any
that
order
case-
can be passed.
in that case, my lord, inherent powers can always be exercised by this honorable court without even a specific prayer being made. My lord, that is the law. If required, I'll be,
Proper application
I
has
may
to
be-
be filed. Be
I
there.
may be permitted to file submit citations on that.
Okay, we will dispose it. The present application has been filed under section 483 BNSS for grant of bail to the accused and for modification of this court's order dated 19/9/2025, passed in bail application number 17 of 2025. Stop. Because our main concern, all of us, is that the court's order should be complied with.
Yes.
So we will pass Mrs. Road. Stop. Learned counsel for the petitioner, Mr. Sentianger, as well as Learned PP, Miss Mary, for the state respondent. Stop. The case of the petitioner is that that the petitioner had earlier filed bail application number 17 of 2025 before this court. And this court, by order dated 19/9/2025, had allowed that the bail order was 32, no?
Bill, application.
Had allowed the petition with the following conditions. Number one, execution of a bail bond of rupees 50,000 with one surety of like amount, who shall be a local resident of Kohima. Number two, the accused shall cooperate with the investigating agency, and he shall not try to influence or tamper with the evidence, and he shall not leave the jurisdiction of the trial court without permission of the court. Stop. Thereafter, the petitioner had approached the trial court for execution of the bail bonds. However, it is stated at para 8 of the petition that the learned special judge NDPS Kohima expressed difficulty to execute the order of this court dated 19/9/2025, passed in bail application 17/2025, by verbally citing that no specific direction has been given to the trial court to execute the said bail order. Stop. Being left with no other option, the petitioner is now before this court praying for modification of the order dated 19/9/2025, passed in bail application 17 of 2025, in order to enable him to execute the bail bond of rupees 50,000 to the satisfaction of the trial court. Stop. Para. At the outset, the learned PP has objected to the maintainability of the present petition on the ground that the bail has already been granted by this court, and therefore there is no possibility of a second bail application being filed by the petitioner when his previous petition has already been allowed and the matter has been disposed of finally. Stop. Learned PP also submits that as per section 362 of the CRPC, corresponding to 403 BNSS, the no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same, except to correct a clerical or arithmetical error. Stop. Learned PP has therefore submitted that the present petition has been filed on the wrong premises of law. Stop. Para. The court has considered the submissions of the learned counsel for the petitioner as well as the learned PP. Stop. This court is concerned with the implementation of this court's order dated 19/9/2025, passed in bail application 17 of 2025. Stop. There is no bar for this court to treat the present petition as one under section 528 BNSS/482 CRPC and in exercise of and to exercise the inherent powers of this court in the interest of justice. Stop. Para. The High Court does not itself take bonds, and the execution and verification of sureties are to be done by the trial court or the court in session of the case. Session is SEISIN, okay? Or the court in session of the case. Stop. It is implied that, it is therefore implied that the bonds will be executed before the trial court. Stop. Accordingly, this application is disposed of with the direction that the execution of therefore this application is disposed of with a clarification that the execution of bail bond of rupees 50,000 with one surety of like amount shall be executed before the trial court concerned. Yes, this petition is disposed.
My lord,
That will do, yes.
if the second condition, in the second condition, my lord, I've also made a specific prayer for that. If the accused may be allowed to leave the jurisdiction of the court.
No,
with the permission-
that you have to apply, before
with
the
the
trial.
permission of the court or IO.
No, not IO. You have to apply before the trial court. Anytime, if you want to leave, you have to apply before the trial court.
Motion, item number 45.
Same.
Yes, my lord.
Son also. Same order.
Yes.
An order of the
Yes.
order date, this
Over
court's
the
order.
22nd of September, and the bail application is 18.
Bail application number will be 18 and this court's order will be
22nd September.
22nd, 22/9. So there also same conditions,
Yes.
same condition.
Yes, same
Same condition.
Deeply obliged.
Thanks. I'll do it. Send it to my.